Are we set, Soupy?
Yeah.
Okay.
Ready to go.
Good morning, all. Welcome to the Judiciary Committee meeting for Monday, April 4th, 2022. We are here today to have 4 confirmation hearings for judges in the district court, beginning with 2 persons being nominated for active retired status, that being the Honorable Peter J. Goronides, followed by the Honorable Ray Ann French. After that, we will have 2 new nominees for the district court, Andrew S. Robinson of Farmington and the Honorable Amy Faircloth of Bangor. Before opening, excuse me, the hearing on Judge Goronides, I will have committee members introduce themselves, and I will call on those who are attending remotely at first in the order that they appear on my screen, beginning with Representative Jim Thorne.
Thank you, Mr. Chair. My name is Jim Thorne. I represent House District 103 in the towns of Carmel, Herman, and a portion of Etna up in beautiful Penobscot County.
Thank you, Representative. Representative Galgay Reckett.
Good morning. My name is Lois Reckett, and I represent District 31, which is the ocean end of South Portland.
Thank you. Representative Newell.
Thank you, Mr. Chair. Good morning, everyone. My name is Rena Newell, and I represent the Passamaquoddy tribe.
Thank you, Representative. Representative Poirier.
Thank you, Mr. Chair. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you, Representative. Representative Evangelos.
Thank you, Mr. Chair. Good morning, everyone. Sorry, I was a few minutes late. I apologize. Good morning, Judge Goronides, and I'm Jeffrey. Good morning, Jeffrey Evangelos, House District 91. I reside in Friendship.
Thank you, Representative. Representative Moriarty.
Thank you, Mr. Chair. Good morning, all. I am Steve Moriarty. I represent my hometown of Cumberland and part of Gray in House District 45.
Thank you. And my Senate co-chair, Ann Carney.
Good morning, everyone. I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, where I live, and a little bit of Scarborough. It's nice to see you all this morning.
Thank you and good morning. My name is Tom Harnett. I serve as the House Chair. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside. I will begin by opening the nomination hearing of Judge Goronides. This is a public hearing of the Joint Standing Committee on Judiciary for the purpose of considering the nomination by the governor of the Honorable Peter J. Goronides of Cumberland for reappointment as an active retired judge of the district court. The meeting today is being conducted using a hybrid format. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, Senator Carney and I will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other persons present who wish to speak for or against the nomination. Before we get started, I want to share some information related to the fact that this meeting is being conducted using a hybrid format. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is participating via Zoom can be seen and also heard if their microphone is unmuted. People testifying via Zoom cannot be seen or heard until they are called upon to speak. This meeting will be recorded and will be available to view on the committee's YouTube channel shortly after we conclude our day's work. I'll proceed to a motion to confirm. Pursuant to Title III, Section 157, I'm sorry, Representative Thorne, you had a hand up?
Yes, Mr. Chair, sorry to interrupt, but Representative Libby is in the waiting room, ready to be brought forward.
Okay, I will ask the committee clerk to move over Representative Libby. I also see we have been joined by Representative Sheehan. Representative Sheehan, if you could introduce yourself, please.
Thank you, Mr. Chair, and good morning, everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Thank you, Representative. And Representative Libby.
Good morning, all. I am Representative Laurel Libby. I represent Auburn, part of Auburn, and all of Minot, and I reside in Auburn.
Thank you. And I will return to the motion to confirm. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Moriarty for the purpose of making such a motion.
Thank you, Mr. Chair. I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Peter J. Goronides of Cumberland for reappointment as an active retired judge of the District Court.
Thank you, Representative Moriarty. Do I have a second? Seconded by Senator Carney. The statutory requirements for this position are posted on the committee's webpage. I will now recognize Jerry Reed, counsel for Governor Janet T. Mills, for the purpose of making a statement concerning this nomination. Welcome, Counsel Reed.
Thank you. Good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Jerry Reed. I'm counsel to Governor Mills, and it's a pleasure for me to be here this morning to ask for your support for the governor's nomination of the Honorable Peter J. Goronides for reappointment as an active retired judge of the Maine District Court. Judge Goronides was appointed to the District Court in 1988 and has been reappointed 4 times, most recently in 2015, at which point he took active retired status. He has presided primarily in Portland District Court. Prior to joining the bench, Judge Goronides spent 3 years as an assistant attorney general in the criminal division of the Attorney General's office, followed by 12 years in the general practice of law at a small firm in Portland. Judge Goronides is a graduate of the University of Maine with a degree in economics and the University of Maine School of Law. Judge Goronides has long been one of the district court's leading experts in family law, and in 2014 received the Maine State Bar Association's Family Law Achievement Award. He is a knowledgeable, efficient, and compassionate judge who skillfully meets the challenges presented by pro se litigants. He has a particular gift for working with people to help them find common ground to resolve their disputes and avoid the time and expense of litigation. On behalf of the governor, I respectfully request your support for the nomination of the Honorable Peter J. Goronides as an active retired judge of the Maine District Court, and would be pleased to answer any questions you may have.
Thank you very much, Mr. Reed. Are there questions for the governor's counsel, Jerry Reed? If so, if you're in the room, please raise your hand. And if you are participating remotely, please raise your electronic hand. And I am not seeing any, so thank you very much for your testimony and for presenting this nominee. I will now recognize John Hobson, the chair of the Judicial Selection Committee. Welcome back to the Judiciary Committee, Mr. Hobson. Please begin when you're comfortable.
Thank you very much, Representative Harnett, Senator Carney, members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I am chair of Governor Mills's Judicial Selection Committee. On behalf of the committee, I request that this committee act favorably on the nomination of Judge Goronides. Judge Goronides had a long and productive career in one of the busiest courts, district courts in the state of Maine. Judge Goronides was always known for being able to separate the legal chaff from the legal kernel. He could always get to the core issues and do it relatively expeditiously while keeping the courtroom both in order and making people feel like they had been heard. Those are qualities that are important for any judge at any time. But in today's environment, with us in the hopefully post-COVID-19 era, with the impact that has had on our judicial system, having Judge Goronitis be willing to do active retired status and to help this state go through what is going to be a difficult time to get through the backlog of cases is really a great public service. And Judge Goronitis could be off sunning himself in some sunny clime and enjoying the benefits of retirement. Instead, he's chosen to serve the people of the state of Maine and slave away in the district court, really doing a public service to the Maine people. And I requested this committee take Judge Goronitis up on his offer and put him back in a position that he served the state so well. Thank you. If you have any questions, I'd be happy to answer.
Thank you very much, Mr. Hobson. Are there any questions for John Hobson from committee members? I am not seeing any. So again, thank you for your time. And before turning to the nominee, I failed to introduce two very important people to our process. One is Peggy Reinsch, our analyst from OPLA, who just popped up on screen. Thank you, Peggy. And the other is our committee clerk, who's making all of these wheels run, Susan Panett. Thank you both for being here. At this point, it is my pleasure to welcome to the Judiciary Committee the Honorable Peter J. Goronitis for the purpose of making a statement concerning this nomination. Welcome, Judge Goronitis.
Good morning. Thank you, Chair Harnett, and also Senator Kerry and other members of the Judiciary Committee. It's a pleasure to be here and an honor. First, my remarks will be brief. And first, I'd like to thank Governor Mills. I'm honored by her nomination to have me as a second-term active retired district court judge. And I would be remiss in not thanking Jerry Reed, John Hobson, the Governor's Council, and staff, Melissa O'Neill Lowe and John Boucher, Casey Mulligan and Susan Panett, and Peggy, I'm sorry, I lost her name, for their assistance in making this presentation. I'd also like to thank the Bar Association for their support. Today represents my sixth appearance before the Judiciary Committee, having been previously nominated by Governors Baldacci, King, McKernan, and LePage. I appreciated the trust that they placed in me, and also the trust that members of the Judiciary Committee and the full Senate have placed in me in the past. Over the last 34 years as a judge, I would like to point out one thing that deviates from my remarks. I'm not from the other Maine. I grew up in Auburn, and I've sat in almost every district court in the state of Maine except two, and I believe that's Fort Kent and Millinocket. But I travel all over the state, or did in my early parts of my career. So I have a sense of the different values and issues that are represented in our great state. In my career, though, I have heard, I say over 100,000 litigants. I'm pleased to say that I try, and I've been fairly successful in not holding decisions longer than 30 days. I think I've been overturned on 5 occasions, 4 of which I still object to. And I believe, though, that this record demonstrates my commitment to the rule of law and the seriousness with which I take my job. And I think I'll just skip to, during my prior terms, I strive to discharge my duties diligently, faithfully, and I pledge to continue that commitment if this committee in the Senate approves my nomination. And I'm pleased to take any questions the committee has.
Thank you very much, Judge Goronitis. Thank you for your prior service, and thank you for your willingness to continue to serve. I will now turn to questions from committee members, beginning with Representative Reckitt.
Start my day by actually unmuting myself before I talk. It's a rare occasion. Good to see you, Judge Goronides. It's, I have to say, I was horrified to hear your term was up, and glad to hear that you've agreed to stay on as an active retired judge once again. My knowledge of your reputation is legion and all positive. I do want to ask you one thing, because I'm always interested when people talk about their former activities to look at what they've done in the nonprofit world. And I was interested to see your service some time back with the York County, York Cumberland Housing Development Corporation, which I think turned into Avesta. My curiosity is because the paperwork indicates that you worked with them to develop 850 units of elderly and low-income rental housing. My question to you is, how in the world did they manage that level of success? And is there a some kind of hint you could give those of us who are working on that very issue today?
Well, they're one of the very few nonprofit organizations originally that survived part of the Lyndon Johnson rebuilding of the country, and we always strive to get a mix. We serviced mostly rural, smaller developments that most larger developers ignored. It's a different environment now, but I do believe that there are many opportunities to create housing for people in need, and it can be accomplished. It takes more work, more creativity, but I do believe there's a real big place for the public and private sector to contribute to the housing shortage in Maine. I think when I left, I think we had developed or were managing over 1,800 units in York and Cumberland County. It's probably much more by now.
Thank you, Judge Goronides, and thank you for the question, Representative Reckett. Representative Moriarty.
Thank you, Mr. Chair. Judge Goronides, I've always wanted to ask this question of someone during the past 2 years, and in particular, I'm interested in learning of your professional experience in active retired status during the time of COVID and shortened court sessions and availability and so forth. Are you essentially on call, or are you scheduled on a regular but part-time basis? Or is it a combination of both?
Combination. We don't have a regular schedule, although the schedules usually come out for a period of 3 months. Typically, they'll find places where they either need coverage or they want to do extra dockets, and then they'll seek to fill those, and they'll call, email us and say, are you available? And they'll plug you in. It's an irregular process, I have to say. You know, sometimes I'm sitting 8 or 9 times a month, sometimes 1 or 2 days. So it really depends on what's needed.
Thanks very much.
Thank you, Representative Moriarty. Representative Thorne.
Thank you, Mr. Chair. Congratulations, Judge Goronides, for your recommendation to come. Is it out of retirement, am I to understand, or are you coming right from another appointment?
Coming right out of another active retired appointment. I retired from full-time judging in 2015.
Okay. Well, we appreciate your service to Maine. In your remarks, you indicated that there were 5 occasions that your judgments were overturned. And I remember my father used to say, I don't have to be right all the time, just every time. And I was curious if you would share with us, if you can recall one particular case that you felt should have stuck, that you made the call on that was overturned.
Yes. One in which I ruled in favor of a man, a husband came before the court and he had sued his insurance company. and his wife was terminally ill and had been using the only relief that she had from the pain of her illness was through acupuncture. And I ruled that they were of modest means. I ruled that it should be covered under their insurance policy, and they objected, and eventually the insurance company appealed to the Supreme Court, and I was overturned, but I don't regret the decision.
And that was my next question. Would you make the same decision today, knowing what you know?
I would. Well, you know, if the law court said no, I mean, I'd have to follow the law, but
Sure.
absent that precedent, I would.
Thank you for that. Thank you, Mr. Chair.
Thank you, Representative Thorne. Are there additional questions from committee members? I have one, Judge Goronides. One of your answers in your application stuck with me, where you mentioned that even though you've been doing this job for a very long time, you still try to hold on to the premise that there is no such thing as a routine case, because every case is unique and paramount to the persons that are involved. How do you do that?
I think it helps to be naturally curious. Once you realize that every situation is really different, it offers unique opportunities to sort of figure out what's going on in a particular circumstance. And if you're curious about that, it's sort of like little detective stories. And I think you have to keep fresh. And as soon as I've told myself, as soon as I start thinking I'm hearing the same case over and over, it's time to stop the job, because I think people deserve a fresh look at their circumstance every single time.
Thank you for that insight. I greatly appreciate that response. I am seeing no additional questions from committee members. I do want to add, Judge Goronides, that one of the committee members, Representative Chris Babbage, said that he was unable to be here this morning due to a family obligation, but he wanted to send his regards. Apparently you spent some time at the University of Maine in Portland together. I won't give the dates.
Okay.
I will now turn to taking comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted that statement to the committee clerk before today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee upon his request before the committee's vote, and the nominee will have an opportunity to respond to the written comment. Those who wish to speak during the proceedings should observe the following. Those who wish to speak on site in person should do so from the rostrum. Those who wish to speak via Zoom should have registered to testify online before the start of this hearing and will be called upon by me, at which time they will be promoted to panelist status in Zoom and they can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. Those speaking should remain at the podium or on Zoom in the event that members of the committee have questions. After you are done speaking and there are no more questions from the members of the committee, you may return to your seat or will be returned to attendee status in Zoom. I would ask those in the attendee room, if there are any persons who wish to provide testimony in support of the nominee, to please raise your electronic hand so that the committee clerk is able to move you over. I would ask the committee clerk to please move over Frank Bishop. Mr. Bishop, welcome back to the Judiciary Committee. It would be nice to see you again. When you are ready, please activate your video and microphone and begin your testimony as soon as you're comfortable.
Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Frank Bishop. I live in South Portland, and I am testifying today here today as the president of the Maine State Bar Association. Can everyone hear me okay?
Yes, we can.
So as you know, the Maine State Bar Association sends out judicial evaluation surveys to all the attorneys in Maine. We then compile those evaluations and present them to the Board of Governors of the Maine State Bar Association, who vote whether to support that nomination or not. Happy to report today that we're here to support the nomination of Judge Goronides. In summary, I'll try to provide a sense of what Judge Goronides' evaluations were like. Judge Goronides' evaluations show that Maine lawyers find him to be intelligent, compassionate, and even-handed. He is described as impartial, patient, and empathetic. He is praised for his fairness in sentencing and his high level of competence in cases involving children and families. He is especially known for his ability to explain the court's proceedings so that everyone in the courtroom can understand them, making the process run efficiently. These traits have earned Judge Goronides the support and respect of Maine State Bar Association members, Maine lawyers, and Maine citizens. And we urge the Judiciary Committee to give its unanimous support to the nomination of Judge Peter J. Goronides to the Maine District Court. I'm happy to answer any questions that anybody on the committee may have.
Thank you very much, Mr. Bishop. The committee greatly appreciates your participation in these confirmation hearings. Are there questions from committee members for Mr. Bishop? If so, please raise your real hand or your electronic hand if you're participating remotely. I am not seeing any, so again, thank you very much for your time and testimony today. I'm going to ask the committee clerk. I do not see anybody else with their hand up in the attendee room. Is there anyone else who's signed up to testify? There's not. Okay, thank you. All public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by committee. We will vote on the nomination and notify the President of the Senate pursuant to Title III MRSA Section 157 and the joint rules. The vote of the committee must be taken within 40 days from the date of the governor's written notice, and we are within that time frame. The hearing of the Joint Standing Committee on Judiciary for the Honorable Peter J. Goronides of Cumberland for reappointment as an active retired judge of the District Court is closed. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. Therefore, I will ask whether any member present objects to proceeding to take the vote immediately. If so, please raise your electronic hand. And I see that there is no objection. The pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Peter J. Goronides of Cumberland for reappointment as an active retired judge of the District Court be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? The committee clerk will call the roll.
Thank you, Mr. Chair. Representative Galgay-Reckitt.
Yes.
Representative Galgay Reckett votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Kine. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. I will recall the absentees. Senator Kine. Senator Kine is absent. Senator Sanborn. Senator Sanborn is absent. Representative Babbage. Representative Babbage is absent. Representative Hagan. Representative Hagan is absent. Chair.
Thank you very much, Committee Clerk Panett. 10 members of the committee having voted in the affirmative and none in the negative, it is the vote of the Joint Standing Committee on Judiciary that the nomination of the Honorable Peter J. Goronides of Cumberland for reappointment as an active retired judge of the District Court be confirmed. Judge Goronides, we extend our thanks and our congratulations to you on your reappointment. Were we all in person, we would come around and thank you personally, but in this day, we will give you our virtual round of applause and thank you for your continued service to the state of Maine.
Thank you very much. And committee members, thank you very much for the confidence that you've bestowed upon me in voting to support this renomination. I appreciate it and have a pleasant day. Thank you.
You're very welcome. Thank you, sir. We will now take a 3-minute break because the next confirmation is scheduled to begin at 9:45. And I will be turning over the next 2 nomination hearings to my co-chair, Senator Carney. We'll see you all in a few minutes. Thank you.
Good morning again, everyone. It's 9:45 and I think we are ready to begin our next hearing. regarding the reappointment of the Honorable Rayanne French. And so committee members, if you could activate your video so that we can all see you, and then we'll begin the nomination hearing.
I'm having a problem getting this video to work. I'm sorry.
I think there might be something we can do on this end to send you a little message to activate your video. Just
Okay.
one moment and we'll try to do that. Judge French, could you please try logging out and then logging back in, because we're not able to send you that that prompt right now.
All right. I'm very sorry. Let me.
That's all right. Thank you.
Sure, come on over. Zoom us does not have access to your camera until it is quit. Leave webinar.
We can see you.
All right, thank you. Now what?
It's nice
All
to
right.
see your smiling face. Well done on the technical maneuverings.
Thank you, thank you.
Okay, so I think we're ready to begin the confirmation hearing. This is welcome everyone, and welcome Judge French. This is a public hearing of the Joint Standing Committee on Judiciary for the purpose of considering the nomination by the governor of the Honorable, I haven't activated my video. There we go. Of the Honorable Rayanne French of Augusta for reappointment as an active retired judge of the District Court. The meeting today is being conducted using the hybrid format. Under the laws and the joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of committee members present and voting. As chairs of the committee, Representative Harnett and I will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other persons present who wish to speak for or against this nomination. Before we get started, I want to share some of the information related to the fact that this meeting is being conducted using the hybrid format. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone participating via Zoom can be seen and also heard if their microphone is unmuted. People testifying via Zoom cannot be seen or heard until they are called upon to speak. The meeting will be recorded and available to view on the committee's YouTube channel soon after the meeting has concluded. We will move on to the motion to confirm. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee. The chair recognizes Representative Harnett for the purpose of making such a motion.
Thank you, Madam Chair. I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Ray Ann French of Augusta for reappointment as an active retired judge of the District Court.
Thank you, Representative. Do we have a second? Seconded by Representative Moriarty. The statutory requirements for this position are posted on the committee's webpage. The chair now recognizes Jerry Reed, legal counsel for the governor, for the purpose of making a statement concerning this nomination.
Thank you, and good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Jerry Reed. I'm counsel to Governor Mills. And it's very nice to be here this morning with you to ask for your support for the governor's nomination of the Honorable Ray Ann French for reappointment as an active retired judge of the Maine District Court. Judge French was appointed to the District Court in 1991. She assumed active retired status in 2008 and was most recently reappointed in 2015. Prior to joining the bench, Judge French spent 19 years in the Attorney General's office, the first 10 of which were in the Consumer and Antitrust Division, and the remainder in the Criminal Division. She has presided primarily in district courts in Central Maine. Judge French holds a Bachelor of Arts with distinction from the University of Maine and earned her law degree at the University of Maine School of Law. Judge French is known for her expertise in the rules of evidence and civil procedure. She formerly served as the district court's liaison to the Committee on the Maine Rules of Evidence. She is likewise exceptionally knowledgeable in mental health law and family law matters and was chair of the court's Family Division Oversight Team. She is pleasant, courteous, compassionate, highly competent, and her integrity is beyond reproach. On behalf of the governor, I respectfully request your support for the nomination of the Honorable Ray Ann French as an active retired judge of the Maine District Court, and would be pleased to answer any questions that you may have.
Thank you. The chair would ask if any member of the committee has questions of the governor's representative at this time. I'm not seeing any hands up. Thank you very much, Mr. Reed.
Thank you.
The chair now recognizes John Hobson, Chair of Governor Mills Judicial Selection Committee.
Thank you very much, Senator Carney, Representative Harnett, members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I am Chair of Governor Mills' Judicial Selection Committee. And on behalf of the committee, I request this committee to act favorably on the nomination of Judge French for another term as active retired. Judge French brings all the experience that Mr. Reed listed, and she brings the ability to have that experience in the post, as I mentioned, hopefully the post-COVID-19 period, and help the judicial branch. One aspect of Judge French's performance, of particular note as active retired, was the assigning judges and chief judge of the district court were very appreciative of Judge French's willingness on very short notice to drive to and sit in jurisdictions in central Maine when judges get sick or for other reasons, if there isn't a lot of notice about judge won't be able to sit. It's sometimes difficult to be able to use a parochial term, plug in a judge into that slot. And given everything that rides on a court docket and not missing a day, it's particularly important from a scheduling standpoint, efficiency standpoint, to be able to have someone with the experience of Judge French who is willing to basically drop everything and go sit on the bench when another judge just is not able to do it. And therefore, I request that this committee allow Judge French to continue as an active retired judge, including her valuable role as someone who has been willing to, on very short notice, sit on the district court bench, and recommend Judge French's nomination to the full Senate. I, of course, would be happy to answer any questions.
Thank you. The chair would ask if any member of the committee has questions of Mr. Hobson. Representative Reckitt. We're not able to.
Yeah, I got it. Welcome, Mr. Hobson. I wanted to ask you this or make this comment in the midst of what I believe is a totally non-controversial appointment here. And I want to thank you for the thoroughness and the timeliness of the information that you have provided us about all of the judicial appointments that are sometimes crabbed at you about both those things. And I think that this year it's quite different, and I really appreciate your effort in those regards. So I just wanted to say that before anything else of substance came before us. Thanks so much.
Thank you very much, Representative Reckitt, but I will be missed and I will be caught if I don't let you know that really Mr. Reed is the individual who shares that really should get for that. I'm perfectly willing to take it, always am. But realistically, Mr. Reed has really had the laboring oar on that. And I've really enjoyed very much working with Mr. Reed. And he's really, I think, really been diligent about trying to respond to this committee efforts. And so any credit really should go to Mr. Reed.
Thank you for that clarification.
Thank you. And are there any other questions, committee members? I am not seeing any. Thank you very much, Mr. Hobson. Before we proceed, I'd like to give Senator Sanborn a moment to introduce herself.
Good morning. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook. I apologize. I had another meeting at 9 o'clock this morning, and I'm going to be a bit in and out during the day today.
Thank you. The chair now recognizes the Honorable Ray Ann French for the purpose of making a statement concerning her nomination.
Thank you. Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Ray Ann French, and I'm grateful for your consideration of my nomination as an active retired judge of the District Court. And thank you, Mr. Reed and Mr. Hobson. I believe you've heard about my education and employment background, but because I do not know many of you, I will tell you a little bit about myself and the path I took to be here today. I have a very supportive family. My husband, Fernand LaRochelle, to whom I've been married for 48 years, my daughter who lives in Augusta with her family, and my daughter who lives in Cumberland with her family, listening today remotely. I went to law school in the early 70s. I did not know any women who were lawyers. I had been encouraged by my parents to be whatever I wanted to be. I wanted to be a trial lawyer. It was a time when there were no women professors at the University of Maine School of Law, and there were no women judges in the state of Maine. When I entered law school, I was one of 3 women in the first year class. By the end of that year, there were 2 of us. When I was looking for a job during my 3rd year of law school, at least one interviewer made it clear that being a lawyer was not a role for women. I suppose that was common then. Many years later, a colleague sent me material showing that in the 100 years between the admission of the first woman to the Maine bar and my admission, only 43 women had ever been admitted to the Maine bar. I was hired as an assistant attorney general in the consumer division. That was a newly formed division, and it was a very exciting work. We were enforcing a new statute, and in addition to the civil litigation, we worked with the legislature in strengthening consumer protection laws in many areas. In the 1980s, I had an opportunity to transfer to the criminal division where I did trial work, something I had always wanted to do. I enjoyed the trial work. I enjoyed being an advocate for consumers, But in the early 1990s, the times had changed and I was confirmed as a district court judge. It is not something I had ever considered when I was in law school. Being a judge is the best job I've ever had. Every day is different legal issues, different litigants. And every day I can learn something about the law or people or myself. During the years I've served as a full-time judicial officer, I worked on a team that created the family division magistrates who helped stabilize families during divorce, and I served on the Rules of Evidence Committee. When I retired, I still enjoyed my job as a district court judge. But our 2 grandsons had arrived, and my husband and I decided to enter a new phase of our lives. Now we have 2 more grandchildren, and the balance between work and our family is a good one. I'm honored to serve as a judge. And if I am confirmed for another term as an active retired judge, I will continue to work hard and to faithfully and impartially serve the people of Maine. Thank you.
Thank you very much, Judge French, and thank you for your persistence and for changing the face of our profession. The chair would now ask if any members of the committee have questions for the nominee. I see that Representative Thorne has a question. Go ahead, Representative.
Thank you, Madam Chair. And congratulations again, Judge French, for your renomination to your position. And I would echo your sentiments that the professor that you had tell you that women had no place in the courtroom was off base, because it's been my non-lawyer experience that women are very capable at arguing cases. So much success to you along the way. In your questionnaire, you indicated that you served on several committees when you were working full-time. But since you've been on active retired status, you've not served on any judicial committees or participated in judicial administrative work. And I was curious if that was by choice or by design.
My understanding is that where we are most helpful is in the courtroom, filling in for our colleagues who need to be at whatever personal issues, vacations, and their own committee meetings. And so I'm fine doing that.
Okay, thank you for that. Thank you, Madam Chair.
Representative Moriarty.
Thank you, Madam Chair. Judge French, good morning. It seems as though a combination of your time and grade will finish.
I'm sorry, I cannot hear you.
And I neglected to turn on my microphone. That's my fault. I wish you good morning. And I note that the combination of your time and grade, both as a full-time jurist and as active retired status, probably makes you as one of the longer serving judges in our current system. You've had the experience now at the conclusion of your second term as an active retired judge of having witnessed the impact of COVID upon the operation of the courts. And I'll ask you the same question I asked Judge Goronides a few moments ago. What is your schedule, as it were, as an active retired judge these days? Do you serve on a regular basis or more or less on call or as needed?
If you're asking me, is there 1 week every month that I work? That's not the case. When the clerk is filling out the schedule for quarterly, she will contact me with dates in which they need a judge to do the docket. In addition, there are days when my colleagues have emergencies and they could call me that day and ask if I would be available to fill in. So it's not a regular, it's not every Monday, it's not 1 week every month, it's as needed.
I see. Can you give us an average of how many days per month you've been asked to fill in?
I can't tell you how many days a month I've been asked to fill in. I can tell you that I usually work in 2022, which is my clearest memory. I've probably worked 3 to 5 days a month.
Very good. Thank you so much.
Representative Reckitt?
Thank you. Judge French, I was intrigued by two things in your resume. One is that you became a judge a year after I became the director of Family Crisis Services. So we probably are a similar tenure. But the other thing is, I noticed you did online classes at UMA in computer science in 2013 to 2015. What precipitated you to do that at that point? Did it have anything to do with what was going on in the courts, or just trying to enlarge your own capacity?
I was trying to become more proficient in the area. Today, students have computers in the 3rd grade. I got mine much later in life, and I just wanted to be able to do a few more things on the computer. So I went to UMA.
That's great. I too am a late computer person, so I'm empathetic, and I'm appreciative to know that they have classes at UMA. So thank you so much.
Committee members, are there any other questions for the nominee? I am not seeing any. Judge French, thank you very much for your statement and for answering our questions this morning. The chair will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted the statement with the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee upon his or her request prior to the committee's vote on the nomination. And the nominee will have an opportunity to respond to the written comment. Those who wish to speak during the proceeding should observe the following. Those who wish to speak on site in person should do so from the rostrum. Those who wish to speak via Zoom should have registered to testify online prior to the start of this hearing and will be called upon by the chairs, at which time they will be promoted to panelist status in Zoom and can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. Those speaking should remain at the podium or available on Zoom in the event that the members of the committee have questions. After you are done speaking and there are no more questions from the members, you may return to your seat or you will be returned to attendee status in Zoom. I will now recognize persons wishing to testify. Is there anyone in the committee room who wishes to speak regarding the nomination of Judge Ray Ann French? Not seeing any. Now I would ask those who are in the attendee portion of the electronic meeting to please raise your hand and keep it raised until we have heard from each person in the attendee part of the meeting who wishes to speak. And we will first hear from Reagan La Rochelle. Representative La Rochelle, welcome to the Joint Standing Committee on the Judiciary, and you can begin your statement when you're ready.
Great. Thank you very much, Senator Carney. Good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Reagan French La Rochelle. Many of you know that I am in the House of Representatives, elected to serve part of Augusta. I'm here today in support of the nomination of Rayanne French from Augusta as an active retired judge of the Maine District Court. I have known Judge French all of my life. I can confirm that she works very hard to carry out her duties as a judge. I have seen her days, nights, and weekends working on a job that she loves. I can also confirm that she is devoted to her family, her husband of 48 years, her 2 daughters, and her 4 grandchildren, ages 2.5, 6, and 14. Although she does not brag, she is very proud of them and cheers for them in all of the things that they do. You may have also surmised that Judge French is my mother. I'm glad to hear her share some of her background with you and what she faced as a younger woman in the field of law in the 70s. She has always been an impressive role model for my sister and me, and I would agree with the prior statement that her reputation as a judge is exemplary. So I ask that you vote in favor of recommending my mother, Rayanne French, to the position of active retired judge of the Maine District Court. Thank you.
Thank you very much for your statement. Committee members, are there any questions for Representative La Rochelle? I am not seeing any questions for you. Thank you for providing a statement today.
Thank you.
And next, we will be joined by Frank Bishop. And Representative Babbage has just joined the committee meeting as well. Representative Babbage, would you like to introduce yourself?
Thank you so much, Madam Chair. My name is Christopher Babbage. I represent House District 8, which is most of the community of Kennebunk. Thank you.
Thank you, Representative. And Frank Bishop, welcome back to the Judiciary Committee. You can begin your statement when you're ready.
Senator Carney, Representative Harnett, and members of the Judiciary Committee, you'll have to excuse my voice. I have a tear in my eye after listening to that testimony. It was very sweet. My name is Frank Bishop, and I live in South Portland. And I am here today testifying as the president of the Maine State Bar Association. I'm happy to testify today in support of the nomination of Judge Rayanne French. As you know, we send out judicial evaluation surveys to all the attorneys in Maine. When those surveys are returned to us, we summarize them for our Board of Governors. And the Board of Governors votes whether to support the nomination or not. And in this case, the Board of Governors unanimously supports the nomination. So a summary of her evaluations are Judge French is rated good or excellent by 100% of the Maine bar respondents. The results of her evaluation show that Maine lawyers find her to be courteous, fair, kind, and respectful. She is known for her integrity and impartiality to all who come before her, and attorneys and their clients know that they will be treated fairly and without prejudice in her courtroom. Judge French is commended for her knowledge of the law and well-reasoned decisions, especially in cases involving children and families. These traits have earned Judge French the support and respect of the MSBA members, Maine attorneys, and Maine citizens. So the Maine State Bar Association urges the Judiciary Committee to give its unanimous support to the nomination of Judge Rayanne French to the Maine District Court. Thank you very much for your time, and I'm happy to answer any questions.
Thank you very much. The chair would ask if any member of the committee has a question for Frank Bishop. If so, raise your real or electronic hand. I am not seeing any questions. Thank you very much for providing your statement today. The chair would ask if there's any other person in the physical room or as part of the electronic meeting who wishes to provide a statement regarding this nominee. I am not seeing any. All public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee. Then we will vote on the nomination and notify the President of the Senate pursuant to Title III MRSA Section 157 and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice, and we are within that time frame. The hearing by the Joint Standing Committee on the Judiciary for the Honorable Ray Ann French of Augusta for reappointment as an active retired judge of the District Court is now closed. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, the chair will inquire whether any member present objects to proceeding to taking the vote immediately. And so committee members, if you object to proceeding to the vote immediately, please raise either your real or virtual hand. I do not see any raised hands, and so there is no objection. We'll proceed to the vote. The pending question before the committee is that the Joint Standing Committee on the Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Ray Ann French of Augusta for reappointment as active retired judge of the District Court be confirmed. In accordance with 3 MRSA, Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the vote? We are. The clerk will call the roll.
Thank you, Madam Chair. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Kine. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Sheehan. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. I'll recall the absentees. Senator Kine. Senator Kine is absent. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent.
Thank you. 11 members of the committee having voted in the affirmative and 0 members in the negative, it is the vote of the Joint Standing Committee on the Judiciary that the nomination of the Honorable Ray Ann French of Augusta for reappointment as active retired judge of the District Court be confirmed. Judge French, ordinarily we would be coming out from the horseshoe and shaking your hand. We've improvised these days and we would love to offer you a virtual round of applause.
Thank you very much.
Congratulations on your confirmation.
Thank you.
Thank you very much, Judge French and committee members. We have concluded with Judge French's hearing, and we'll have 10 minutes before we start our next hearing on Andrew Robinson. We will see you all shortly. Good morning, everyone. Committee members, just want to let you know that we're getting ready to resume our work for the day with our 10:30 hearing. If you could please activate your video. Thank you. Welcome, everyone. I just have to say this is a session record for the number of people present in the Judiciary Committee room, and it's really nice to see everyone. And so we're going to begin with the confirmation hearing on Mr. Andrew S. Robinson, Esquire of Farmington. This is a public hearing of the Joint Standing Committee on Judiciary for the purpose of considering the nomination by the governor of Mr. Andrew S. Robinson, Esquire of Farmington for appointment as district court judge. The meeting today is being conducted using a hybrid format. Attorney Robinson and his family are here today, and we want to make sure that you feel welcome. We're very happy to see you. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee, of committee members present and voting. As the chairs of the committee, we will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other person present who wishes to speak for or against the nomination. Before we get started, I want to share with you some information related to the fact that this meeting is being conducted using the hybrid format. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who's participating by Zoom can be seen and also heard if their microphone is unmuted. People testifying via Zoom cannot be seen or heard until they've been called upon to speak. This meeting will be recorded and available to view on the committee's YouTube channel shortly after our work for the day has concluded. We will begin with a motion to confirm. Pursuant to Title III, Section 157 of the Maine statutes, which require that there be an affirmative motion to recommend confirmation of the nominee, the chair now recognizes Representative Laura Libby for the purpose of making such a motion.
I move that the Joint Standing Committee on Judiciary recommend confirmation of Mr. Andrew S. Robinson, Esquire of Farmington for appointment as district court judge.
Thank you, Representative. Is there a second? Seconded by Representative Harnett. The statutory requirements for this position are posted on the committee's webpage. The chair now recognizes Jerry Reed, legal counsel for the governor, for the purpose of making a statement concerning this nomination.
Good morning. Thank you, Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Jerry Reed. I'm legal counsel to Governor Mills, and it's very nice for me to be here this morning to ask for your support for the governor's nomination of Andrew Robinson for appointment as judge of the Maine District Court. Andrew Robinson began his legal career at a small firm in Farmington for 2 years before joining the district attorney's office for Oxford, Franklin, and Androscoggin counties in 1999. He then spent 3 years as an assistant district attorney and was promoted to deputy district attorney in 2012. In 2015, he was elected as district attorney, responsible for supervising 13 prosecutors and 22 support staff in all 3 counties. As district attorney, he has served on numerous professional advisory committees and associations, including the Criminal Law Advisory Committee, the Advisory Committee on Professional Conduct, and the Attorney General's Elder Abuse Committee, to name just a few. He's also president of the Maine Prosecutors Association. While district attorney, he personally developed an electronic system for sharing the prosecution's discovery materials with the defense, transforming a highly inefficient system that burdened defendants and their attorneys into a model of efficiency and reliability. He's been an active community leader and volunteer, including as treasurer of Western Maine Community Action, as a member of the Board of Directors of the Farmington Public Library, and as the former president of the Western Maine United Travel Soccer Club. Attorney Robinson graduated cum laude with a degree in English and political science from the University of Maine and earned his law degree cum laude from the University of Maine School of Law. Andrew Robinson is a highly experienced criminal lawyer who has personally handled hundreds of cases and supervised or assisted in countless others. Those who have worked closely with him praise his fairness, his honesty, and his integrity. He's hardworking, thoughtful, and interested in new ideas for improving the delivery of justice. He also has a gift for putting people at ease. He's a highly qualified attorney for a position on the district court, and on behalf of the governor, I ask for your support for his nomination. I'd be happy to answer any questions that you may have.
Thank you, Mr. Reed. Committee members, are there any questions for Mr. Reed? Representative Reckett, go ahead.
Thank you. Mr. Reed, I just wanted to transfer my compliments that I gave to Mr. Hobson in the last confirmation that appeared to have been better suited to give to you. So thank you for the increasingly terrific job that has been done on the sharing of information about nominees with the timeliness with which it's been done. So on that note, thank you.
Thank you, Representative Reckett. I'm glad you feel that it has worked well recently. And if any member of the committee ever has any concerns about issues like that, please feel free to be in touch with me directly.
Thank you.
Thank you. Does any other committee member have a question for Mr. Reed? Not seeing any. Thank you very much.
Thank you.
The chair will now recognize John Hobson, Chair of Governor Mills Judicial Selection Committee.
Thank you very much, Senator Carney, Representative Harnett, members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I am Chair of Governor Mills' Judicial Selection Committee. On behalf of the committee, I request that this committee act favorably on the nomination of Mr. Robinson. Mr. Robinson has all the experience and that Mr. Reed listed. When the committee it looks at applications, when they come from a particular sector, and the prosecution sector is a considerable amount, really the majority of the experience of Mr. Robinson, we want to make sure the individual after that experience will come to the bench and follow in the footsteps of other prosecutors and be fair, even-handed, and that defendants will not only get a fair shake, but get a sense that they're getting a fair shake during the process. There is nothing more important in this justice system that the people within it believe that they're receiving fairness. And so as a part of the process of evaluating applicants, and Mr. Robinson in particular, the committee wanted to make sure that coming from the background that he did, that it was someone that, with all the confidence that we've had in other prosecutors that have taken the bench, that he would fit that mold. Well, he did. The defense bar, the individuals who deal with him on a daily basis or weekly, monthly basis, had very high praise for Mr. Robinson, had very high praise for his trustworthiness, the fact that he would keep his word, and the fact that you could always count on him. In addition, something struck the committee as part of this process that I've always been of the perspective that, and those on the committee will understand this, I think, is that if you put yourself up for elected office for the people, that takes a certain skill and a willingness to listen and a willingness to accept diverse opinions and candidly a patience level that not everyone has. And Mr. Robinson has submitted himself to the will of the people. He's someone who is an elected official. He's gone through that process. And that is a process that when you combine it with Mr. Robinson's personality, which is a dynamic and outgoing personality, will, in the committee's view, suit Mr. Robinson well when he's dealing with pro se's, because he will be able to be approachable and yet be able to administer justice. And at the end of the day, that's what's important, that the citizens of the state of Maine believe that they've received justice and that they feel that they've had a fair shot at the process. And the person wearing the robe that this committee has helped put on the bench is someone that the people have confidence in. And the committee believes that Mr. Robinson will fall in the mold of many prosecutors and be just such a judge. Thank you very much. I'd be happy to answer any questions.
Thank you. The chair would ask if any member of the committee has questions for Mr. Hobson at this time. Do not see any questions. Thank you. The chair now recognizes Mr. Andrew S. Robinson, Esquire, for the purpose of making a statement concerning his nomination.
Good morning, Senator Carney, Representative Harnett, distinguished members of the Joint Standing Committee for the Judiciary. My name is Andrew Robinson. I'm from Farmington, and I'm here today to discuss my nomination as a judge for the Maine District Court. I'd like to begin by communicating how grateful I am and humbled by the nomination of Governor Mills. I'd like to thank the selection committee for allowing me to meet with them and making their recommendation to the governor. I'd like to thank Jerry Reed and John Hobson for their kind words in the introduction. I'd also like to thank you for considering my nomination. I know that you've had an opportunity to review my application and already know a great deal about me. But I thought I would take this opportunity to describe the journey that brought me before you today and some of the lessons that I've learned along the way. I was a military brat. My dad, Richard Robinson, was a non-commissioned officer in the United States Air Force. My first connection to Maine was during my elementary school years up at Loring Air Force Base. We subsequently moved to Spain and then the United Kingdom, where my mom, Sheena Robinson, was from. And after living in England for a while, my dad, who was nearing the end of his 30-year military career, asked to be stationed back at Loring Air Force Base. We moved into a fixer-upper, as he used to call it, in Limestone, and I graduated from Limestone High School. I made my way to the University of Maine, where I met the most influential person in my life, Yvette Robertson. Yvette was a Navy brat and had grown up on the opposite side of the world, and her parents had also decided to settle in Maine. Sometimes I can't believe how lucky I've been in life, and Yvette is my greatest example. We were married a month before we graduated, and last November we celebrated our 30th anniversary. I'm blessed to have someone in my life who provides me with unconditional love and support, and I try to do the same for her. We have 3 amazing children: our oldest son, Zeke, who is 22, our youngest son, Gabe, who is 20, and our daughter, Charlotte, who is 10. I wake up every day knowing I'm the luckiest man in the world. After Yvette and I graduated, we moved to Kansas City while Yvette attended chiropractic college. I, with my English and political science degree, found a job working in a software store. This experience was significant for 2 reasons. First, when a little kid called asking for the code to make a violent game more violent, I told him I couldn't help him, even though I had the code. I picked up the phone and called Yvette and told her I'm going to need to do something different now. And I decided to go to the trade school for liberal arts majors, law school. Beyond making it clear that I need to go back to school, my software store experience also made me comfortable with using software and working with computers, which becomes important later in my professional life. We both wanted to return to Maine, so I applied to the University of Maine School of Law and was accepted. I loved law school. While I was finishing my degree, Yvette found a job in Farmington, and we moved there to be close to her work. After graduating and passing the bar, I was hired to work in a small real estate law firm, Mills and Mills. I had a wonderful boss, Paul Mills, and I learned a lot, but I wasn't spending any time in the courtroom. I eventually began volunteering to represent victims of domestic violence who were seeking protection orders in the Farmington District Court. I coordinated my help with the Abused Women's Advocacy Project, often referred to as AWAP, and later became Safe Voices. I worked with women who were at a very difficult and frightening time in their lives. It opened my eyes to the complicated dynamic that exists in a relationship with domestic violence. Unbeknownst to me, AWAP was co-writing a grant with the local district attorney's office for a domestic violence prosecutor. They were awarded the grant, and when District Attorney Norman Croto asked if they had any candidates that they wanted him to consider, AWAP mentioned there was a young attorney in Farmington who was helping them with PFAs. This is when I met the second most influential person in my life. District Attorney Norm Croto became my mentor and eventually my friend. Norm taught me to look at every case separately. Each case had a different defendant and a different victim and different circumstances. And in order to do justice, you needed to tailor your decisions by taking into consideration all three factors. Norm would also emphasize the importance of public safety, but he would impress upon us the importance of leaving a defendant with a sense of hope. Norm was always a gentleman and always treated everyone with respect. His style of practicing law synced up perfectly with my own. My experience with helping victims of domestic violence secure a protection order was very positive, and I took great satisfaction knowing that I had helped someone. I expected my work as a domestic violence prosecutor to be received in the same light. This was another learning experience for me. I often found myself talking with victims who were not happy about my involvement in their personal lives and the possible impact it would have on them. This was counterintuitive to what I expected, but when I thought about it, it made sense. When I was working to get the protection orders, it was at the victim's request, and they had made the decision that they needed one. They had control over the content of the order, and it allowed them time to decide what to do. When I met with a victim after we charged a domestic violence crime, they were often worried about the impact that it would have on the defendant if he went to jail, and which would likely have an effect on their children and family, both emotionally and financially. I quickly realized these cases, and most criminal cases, are not black and white. They are complicated. And if you don't balance the needs of the victim, the defendant, and public safety, you are very unlikely to achieve justice. After a year of being in the domestic violence grant position, Norm hired me as a permanent assistant district attorney, and I was based in Franklin County, where I covered all types of cases, from traffic tickets to attempted murder. I was unofficially the district's cover person and would regularly provide coverage for all of the district courts in the region. I would help in Rumford, Lewiston, Livermore Falls when they had a district court, and South Paris. I watched how different judges handled the dockets and how they interacted with defendants. I watched how treating someone who is clearly in a stressful situation with respect and in a calm manner would make all the difference. My journey as a prosecutor and eventually a district attorney is pretty well documented in my application. Frankly, I wrote out the entire journey and how different experiences influenced me, but when I started practicing, it was taking too long to get through it. It's hard to summarize 23 years of public service and growing as a person in a short period of time. But I thought I would compromise by giving you the highlights, and then I will gladly answer any questions from the committee members. One day in 2014, Norm told me that he decided that he was going to retire and wasn't going to run again. He told me that he thought I should run to be district attorney. I'm not being dramatic when I share with you that Norm was a father figure to me, and this conversation left me wondering how I could ever fill his shoes. But I decided I should try. While district attorney, I've relied on my life lessons and experiences. I've tried to treat everyone with respect and dignity, always considering the needs of the victim, the defendant, and public safety when making decisions, recognizing that each case could have a dramatic impact on other people's lives. I've used my software skills to modernize the way our office functions. We use cloud distribution to provide discovery and automated software to reduce the work of our support staff. I've worked very hard to expand our treatment courts, which are inspiring and a different way of thinking about criminal justice. In addition to the existing treatment court in Androscoggin County, we are starting a treatment court for Oxford and Franklin counties and a new mental health docket in Androscoggin. I've developed diversion programs for shoplifting, for people with substance use disorder that are charged with low-level crimes, and restorative justice for young adults entering the criminal justice system. While DA, my personal growth has continued. I began teaching law classes at UMF. One was a survey course that touches on all areas of law. I enjoy teaching about family law, probate law, contracts, business, torts, and constitutional law. I suspect few people would guess that my favorite area of law to talk about is products liability. Other classes I have taught include criminal justice reform and the trial system. Every time I teach a class, I learn more about justice, and I try to improve the work I do in the office. I believe my life experiences, my work as an assistant district attorney, my work as district attorney and a law professor have prepared me well to serve as the judge for the District Court of Maine. However, I know I have a lot to learn, and I'm committed to developing my skills and knowledge in the areas of law that I haven't been exposed to during my career. Just as importantly, if I'm lucky enough to be confirmed, I will work tirelessly to ensure that I live up to the high professional standard required of a jurist in Maine, and will treat each person with respect and compassion. I thank you for taking the time to listen to me and will gladly answer any questions you may have.
Thank you very much for your statement. Now, the chair would ask if any member of the committee has questions for the nominee. Representative Evangelos, you can go ahead. We're not able to hear you, Representative.
Sorry. Thank you, Madam Chair, and good morning, DA Robinson. First of all, I have a comment and then a question. Everything I've done researching your background, everything Mr. Hobson said about you is true. Defense counsel speak highly of you. So we're grateful as a state that your mom and dad moved back to Limestone. I also remember appearing before Clark for my parole bill. And you were supportive, so always to be remembered. I do have a question and a concern, not about you, but about a matter of law. So now as a sitting judge, a case comes before you and the defense provides evidence to you that the defendant's right to confidential communications with counsel has been violated by either corrections or law enforcement, and that information ended up getting shared with the prosecution. Now you're a sitting judge and this comes before you. Given that those activities are unconstitutional and against the law, I want to know how you're going to handle that situation in light of Representative Harnett's efforts to bring some reform to that area. So that's my question. Thank you.
Thank you for that question, Representative Evangelos. That was actually a product of one.
I believe that the microphone has turned off. Just one moment and we can fix it.
Yeah.
Yeah, can you start from the beginning, please?
I wanted to thank you, Representative Evangelos. And before I answer your important question about the privileged communications between counsel and their clients, I did want to point out that the CLAC meeting where we were discussing parole, that discussion occurred right after I had been reading an article about parole and its purposes for the class I was teaching. And so it's an example of where learning outside of my normal role in the office helped me have a better understanding of the ideas that were being put forth. As far as a violation of an attorney-client privilege, I, of course, would need to know all the specifics and would expect to receive that information. If a finding it was made that the attorney-client privilege had been violated, then I think the remedy available is that it should be suppressed and kept out of the case. And then to the extent that it impacted the ability of the state to have a fair and impartial representative, someone who did not have access to knowledge that would prejudice the defendant, then I would ask that, or I would order that attorney be excluded from the case. If I found that the attorney did not receive the information or didn't have an impact, that would be something that I would explore. But I do believe a constitutional violation and certainly the violation of the attorney-client privilege is one where the evidence should not be admitted into the case in chief.
Thank you. Thank you very much for that. Should there be any consequences for the people that engaged in that activity besides the suppression of the evidence?
Well, I think there needs to be, I would need details. If it was an intentional interception of the communication, then I do think there would be consequences. But I would need more information about how the information was obtained and why it was in the possession of the state.
And that's obviously a reasonable answer because every situation is different. I understand. And thank you for your answer, sir.
Thank you.
Representative Thorne, go ahead.
Thank you, Madam Chair. And welcome, District Attorney Robinson. Congratulations on your nomination.
Thank you.
And I can certainly appreciate a couple experiences of your life. One, I grew up in Presque Isle. And two, I spent 20 years in the Air Force and had 2 daughter brats. So I appreciate your being dragged around not only the country, but the globe. And it goes back to everything else. Whatever doesn't kill you makes you stronger.
Exactly.
My question for you is, being the non-lawyer on the group, I always ask the outside non-technical questions, but what would you categorize as the one thing that you're most apprehensive about in becoming a judge?
I think it's a wonderful question, and thank you for that, Representative Thorpe. The apprehension comes, I think, on 2 levels. One, I have a steep learning curve where I am going to need to educate myself about the areas of law that I haven't seen to this point in my career. And it caused me enough concern that I did reach out to colleagues who were similarly situated in their careers that eventually were prosecutors that went to the bench. They explained to me that it's manageable, and they expressed confidence that I would be able to handle that. I also approached colleagues who came from the other arena, civil law, and talked to them about the learning curve for them. And I did have someone who said to me, geez, Andy, the notion of a motion to revoke bail on a probation revocation, the concept itself took a while to understand. And so we all have our learning curves, and you're going to be fine. And then ultimately, the thing that gave me the most comfort and which was astounding to me is that each and every person that I spoke to about this concern then offered to assist me in any way they could, gave me their cell phone numbers and told me I should be in contact with them if I ever had any questions. That put my mind at ease. But I think that was the largest concern I had.
Thank you for that, and best of luck to you.
Thank you.
Representative Reckitt. We're not able to hear you.
Good morning, Attorney Robinson. My devastation about this is that I'm not there in person. I had really hoped to see you today. I'm not feeling particularly well, and so I'm staying home and taking that way out. But I wouldn't have missed your hearing for all the world. I'm a great admirer of you. You might or might not know. I want to review a couple, 3 things you said in your materials that struck with me. One is one that I think speaks to your temperament, and it was a quote you did from a former Attorney General of the U.S., Robert Jackson, when you said the citizen's safety lies in a prosecutor who tempers zeal with human kindness. And I personally believe that will be your attitude on the court, and I'm pleased about that. The other things that I wanted to raise up are that I think are congruent, but some might think not. One is your belief that you should hold a person accountable for what your conduct was, but to avoid harsh penalties that don't further the state's goals. Can you think of a circumstance in which that particular fact pattern might arise when the possible punishment doesn't fit the crime, I guess would be the best way to say it?
I think probably the best example I have is the a case that I talked about with the animal cruelty involving State v. Peck. That is one where the charge of cruelty to animals has a mandatory minimum fine. And the goal of the state, this was a case where the owner had too many animals and was not able to provide sufficient medical attention for them, and they were becoming sick. The goal of the state was to limit the number of animals. And if we had brought a count for each animal, the result would have been, I'm doing this off the top of my head, but I think it was around $22,000 in fines. And instead, what we tried to do was approach it from bringing one single charge, make it so the court could consider all of the evidence with relation to that charge, limiting the exposure of the defendant to a mandatory fine of $500 and allowing the court to be able to impose the injunction that we thought was necessary to limit the number of animals the person owned. So it's an example of, I think, an automatic reaction is to bring a count for each animal and then proceed. But the impact on the defendant, I think, would have been much greater than what the state needed to accomplish in that case.
Thank you. If I could ask one more question.
You may.
Madam Chair. I was admirous of your grant success that helped with the basically the case management software with the judiciary. I'm aware of the decades of struggle that the judiciary has had in bringing their systems into reasonable 21st century technology. And I'm hopeful that once you are firmly seated in the role as a district court judge, you might be of assistance to the judiciary in further implementations. But I'm really my personal concerns, and you should tell me I'm just overreacting. I know of the work of your office in a number of different areas, but the one that I am most admirous of is the work that your office has done in the arena of human trafficking. And I'm hopeful that knowledge that you've gained in that will guide you in district court to some extent. Not that there are a million cases that come forward, but can you say whether or not the work of your office in that area has expanded your view of victimization?
Thank you, Representative Reckett. I do want to thank you for all of your thoughtful questions. And I do want to just add, I think I should get a daily phone call from you because you make me feel good about my ego. But I will tell you, this is an example where hiring smart people is truly my genius. And I have an assistant district attorney who has dedicated his professional life to educating himself and our office about human trafficking. His name is Nate Walsh. His work is one that is, I think, considered to be the foremost and prominent in the state of Maine. And he has provided me insight that I did not have when I started as district attorney. And he has made it so that we have tailored and crafted procedures and identified cases in our office that we should be handling with a level of sensitivity because of the human trafficking component. So I would encourage everyone to hire smart people.
Thank you for
That's it for
your
me.
questions and for your answers. Representative Harnett?
Thank you, thank you, Madam Chair. Welcome, DA Robinson. After 2 years, it's nice to see you in person and not in one of those little boxes over on the screen. And congratulations on this nomination. You mentioned that you taught a course on criminal justice reform, which might surprise people given your role as a district attorney. But as we know, that's one of the charges of those on the prosecutorial side. But I applaud you for that. And you've been in front of this committee enough to know that we are always interested in ways to keep people hold them responsible for their actions, but to keep them out of the criminal justice system if it's not necessary for them to enter it. And you talked about two ways to do that. One is your diversion program, which you said is one way we could improve the judiciary. And the other is your work on treatment courts. And I wonder if you could just touch a little bit on the humanity that can be saved by using those programs, as well as the financial cost of putting someone in prison when they don't need to be there.
Thank you for that question, Representative Harnett. And it goes to the heart of what I consider to be one of the most important programs that we have in the criminal justice system. When you have identified someone whose criminal conduct is intertwined with an addiction, and that substance use disorder is a driving force in the commission of the crimes, the only way that you are going to stop the cycle of criminal activity and avoid recidivism is to address the underlying substance use disorder. And so in an arena where it's adversarial and typically the charges are brought, a finding is made of whether or not the offense was committed, and then a sentence is imposed. The treatment courts are an arena where you are actually having interaction with an individual who's been charged with a crime, and you're reinforcing and supporting their positive behavior. And you're showing them that the community wants them to be successful. It is what I consider to be, I wish every case could be treated that way, but it's resource heavy and very demanding. The impact is you are less likely to see that person commit a crime in the future. And then directly to your point about the cost, it results in somebody not being incarcerated. And the number that sticks out in my head is $50,000 a year for an adult to be incarcerated. So if you can take a case where you're not jeopardizing public safety, but you're addressing the underlying issue so you don't have future cases and you're not going to meet new victims or future victims, and you can obviate the need to incarcerate somebody for 2 years, 3 years, so $100,000, $150,000, that's a win-win. And it is a wonderful way for the criminal justice system to address the conduct. I often talk about treatment courts, and I've been to Rotary meetings, and I always say to them, look, if I can't get you in the heart, I'm going to get you in the wallet, because this just makes sense either way you look at it. But it is resource heavy and intensive, but it is incredibly rewarding, both as a prosecutor and somebody who is responsible for the criminal justice system, and I think for the individuals who have to go through the program.
Thank you.
Representative Babbage?
Thank you, Madam Chair. Thank you very much. Good morning, DA Robinson, and congratulations. I didn't realize that you had this limestone connection. Did you ever have Sandra Layton as a teacher by chance?
Yeah,
Did
she was
bring
my
you down?
history teacher. Isn't that funny?
So. Yeah, she's a wonderful woman.
Oh, just extraordinary. Oh, it's funny you mentioned her. Well, that's
I think she'd be very proud, Andrew. So,
and surprised, Representative Babbage, and surprised.
I wanted to, one of our jobs here is to evaluate judgment. And, you graduated from law school and had the world in front of you. And, when an athlete is interviewed after a championship and they say, what's next? I've never heard them say, I'm going to Kansas City. But as an employee of Babbage's, I wanted to also, I know that one side of our family did start misspelling it about 1700. And I've always wondered whether there was a member of the family involved with that institution or if it was a reference to Charles Babbage.
It's a reference to
that's
Charles.
That's for another time. You could,
Okay.
But more seriously, I did want to ask you about, many of our colleagues here on the panel have touched on things that I would have touched on as well. And certainly you are worthy of a great deal of praise, and we all think very highly of you. I do want to ask, in your experience as a prosecutor, has there been much variation in judges' instructions to juries? And also, can you explain what might be a situation, or could you see yourself ever setting aside a jury verdict?
Well, I think, one, thank you for that question. And the two things that come to mind. One, you should be very cautious about deviating from Don Alexander's treatise on jury instructions. And anyone who does decide to do an alternative instruction does so at their own peril. So I generally rely on that text when making recommendations to the court. And I suspect, although the position that we're talking about today would be in the district court, with the UCD, I have seen district court judges who make guest appearances and administer the jury trials. If I were to speculate, and I would need a lot more information, but if I thought that a motion for acquittal were made, and I would suspect the court did not grant that motion, and then the defense put on its case, and at that juncture, it became very clear to the court that there was not sufficient evidence to support the verdict. It'd have to be an extraordinary circumstance. I'm having a hard time sort of picturing it in my mind, but I would not say it, it's impossible or it would never happen, but it would have to be a result where the matter went to the jury. While it was considering the verdict, the court made a determination that the one party had not met its burden, and therefore the verdict should not go through. This reminds me of a very recent situation where it was a defamation case, and I forget, I believe it was the former governor of Alaska had sued the New York Times, and the judge made a determination that it was not going to allow a verdict to go through. Because it felt that the plaintiff had not met the standard to show that defamation had occurred or that all the elements were met. Ultimately, the jury came back with a verdict in favor of the defendant, New York Times, so it was a sort of a non-issue. But I think the court had communicated that it was not going to allow that verdict to stand at that point. So that might be an example. If I were to have an ex-Alaskan governor suing the New York Times in the state of Maine, under those circumstances, I would probably look at it the same way.
Yeah, okay, thank you for that. And if I just may make a statement to conclude here, Madam Chair, I thank you with the district court reference. I realize it would be less frequent, but I was thinking about your vast experience as a prosecutor. Attorney Robinson, you're intelligent and very competent, and have proven yourself open to change as well. So I just wanted to say that I'm pleased to be part of this. Congratulations on your nomination, and thank you for your elevated level of public service that you're about to embark on.
Thank you.
Appreciate it. Thank you, Madam Chair.
Representative Reckett?
Yes, my comment is really to Representative Babbage to challenge his memory, because there is a song that starts with I'm going to Kansas City, here I come. I can't remember who sang it, but it was a country star. I'm certain of that. I'll try to look it up for you, Chris.
Thank you.
And if I find it, just Attorney Roch, thank you.
We actually danced to that during our honeymoon right before we left for Kansas City. We were just about to graduate, and then we left the following week. So we danced to that song.
I stand corrected.
I'm glad we got that squared away. Committee members, are there any additional questions for the nominee? I am not seeing any. Thank you very much for providing your statement and answering all of our questions.
Thank you. I appreciate your time.
The The chair will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted the statement with the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will also be made available to the nominee upon his request prior to the committee's vote, and the nominee will have an opportunity to respond to the written comment. Those who wish to speak during the proceedings should observe the following. Those who wish to speak on-site in person, and I will ask people on-site to speak first, should do so from the rostrum. Those who wish to speak via Zoom should have registered to testify online prior to the start of the hearing and will be called upon by the chairs, at which time they will be promoted to panelist and can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. Those speaking should remain at the podium or available on Zoom in the event that members of the committee have questions. After you are done speaking and there are no more questions from members of the committee, you may return to your seat or you will be returned to attendee status in Zoom. We'll now recognize persons who wish to testify. We'll start with those who wish to speak in favor of the nominee, and we can start with Megan Maloney.
Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Megan Maloney. I'm the District Attorney for Kennebec and Somerset Counties and the President of the Maine Prosecutors Association. I am here today in support of Andrew Robinson on his appointment to the Maine bench. Andy is one of the kindest, hardest working, and intelligent people I have ever known. A great leader focuses first on providing the public with reliable, fair service, and second, on fixing any problems. Andy has always been that leader. I know well the people who work in his office, the people who interact with his office. He is praised as considerate, dependable boss, and a responsive community leader. Everyone will miss him greatly. Andy is a district attorney who has worked with his heart and his head. I've spoken in support of my former classmate and soon-to-be Justice Ketanji Brown Jackson, saying that what makes her particularly qualified is her time as a public defender. Likewise, it is Andy's time as a prosecutor that makes him particularly qualified. The two jobs are similar because being a defense attorney and being a prosecutor gives a person daily one-on-one contact with the greatest problems facing our society. We see domestic violence, child sexual assault, vehicle manslaughters, and child pornography. Both defense attorneys and prosecutors see this every day. We don't just read about it, we see it. We see the pictures and the videos. We try to keep our composure as people sob and scream, overcome with the pain of life. These experiences mark our hearts forever. I know Andy has often felt the pain of victims, but perhaps what really makes him unique is that he has also felt the pain of defendants. As you know, prosecutors cannot typically speak directly with defendants, but after a defendant resolves his or her case and enters a treatment court, we are allowed to talk directly. As the attorney for his treatment court, Andy has learned from the participants about their lives, their childhoods, their struggles. He has learned about the connection between ACEs and criminal behavior from books and from the people themselves. I would argue there is no better teacher than the person with lived experience. Andy has worked with the treatment court participants, listened to their pain, and celebrated their victories. He has witnessed the success of restorative justice firsthand and will bring this with him to the bench. Andy knows in his heart and in his head that people need opportunities to succeed in life, and our criminal justice system needs to give people those second chances. Our judicial system wants to expand the number of treatment courts, and I know Andy will always be happy to volunteer to help. I have also seen Andy in action as the statewide president of the Maine Prosecutors Association. I can personally say it is a lot of work, of extra work that's completed on weekends and nights, and there is zero extra money. It's not about the money. It's about our community and doing our part. As our president, Andy worked endless hours to move our state to an electronic discovery system. It is the single biggest change that our state has made to get information to defense attorneys faster. We have all watched television shows and movies where an attorney is buried under a truckload of paper. Because of Andy, all that paper is replaced by a cloud that holds all the information on a case. When law enforcement uploads new information, both the prosecutor and the defense attorney receive it at the same time. No advantage to the prosecution. No ability for an unscrupulous prosecutor to withhold anything. This change is monumental. This is because of Andy. Andy also worked to bring us the statewide training on implicit bias and a new restorative justice program for those under age 26. I'm convinced that Andy never sleeps. It is my great honor and privilege to recommend to you Andrew Robinson for appointment to the judicial bench. He will serve with kindness, compassion, intelligence, hard work, and honor. Thank you, and I'm happy to answer any questions.
Thank you very much. Committee members, are there any questions for Megan Maloney? I don't see any. Thank you for your statement today.
Thank you.
And I think probably the best way to proceed with additional public statements in support of the nomination is for anyone who's sitting in the same row as Megan Maloney, if you could please step forward if you're planning to make a statement. Thank you. Welcome.
Thank you. Good morning. My name is Fatima Hussein. I am a resident of Auburn, and I am here to support Andy's confirmation to the bench. I know that a lot of folks talk to the experiences of Andy from a system perspective. I'm here to speak from a community perspective. Obviously, I'm from the Lewiston-Auburn area, so we're very proud. First of all, I want to say that he is leaving a very strong office behind. The people who are there are extremely genius. They work so hard, and they've integrated so well to be able to serve anybody who comes through their doors. And it's because of the leadership of Andy. Andy has worked with us for the past 8 years. He has gone to community events. He's come to Friday prayers. He's talked to people on the streets, in the office, in their homes, in outreach places, in businesses. We've had a lot of Somali food together. In Lewiston-Auburn, we are known for our hospitality, and therefore we welcome people. And so that's one of it. The other piece is Andy is someone who upholds the law. That's extremely very important to him. He also has a human heart, and that's also equally important to him. We come and look at cases that are very complicated. The communities that we serve are immigrants, asylum seekers, and refugees. They're mostly Black and brown people. They're people who deal with immigration and other issues. We are underserved. We're people who don't understand the laws of this country. Needless to say, we don't know how to navigate the laws of this country. We're brand new and we have large families. Of the large families, we have a lot of young people who interact with the criminal justice system. And therefore, what we've done for the past 8 years is not only to educate the system, but to also educate the community so that there's integration as they move forward. In every case, we look, we see, we look at the avenues of both supporting what you said, my friend here. What you said is, do we need to have people in the criminal justice system if in fact there are other avenues? And that's what we do. We have worked on so many different cases. And those people that Andy and his staff worked with on their behalf to either hold them accountable or to have them have services or to send them to places where they didn't have access to services. Today, they thrive, they're good citizens, and they abide the laws of this state and this country. The other piece that we've done together is training. We know that we have to have training for his staff and the entire system. And so we've done a lot of cultural competency trainings, whether it's over lunch at a staff meeting, but in this year also with his leadership, the idea of really working in 5 district attorneys' offices where we actually are looking at racial bias, justice training, and that has been going together. Last year, with his leadership and other DAs, they have brought in Mindbridge, has done a lot of work around what is it that we need to do for communities that are on the edges, particularly BIPOC communities. And that has been really the foundation of our collaboration, our partnership. And lastly, I'm gonna say that for the mother, the particular, immigrant mother who don't speak English, who don't know how to navigate the system, particularly in this case, who needs help, our DA office has become a wide open door for them. People come in, out. We know who Andy is. We want Andy to be the next judge. We want Andy to be confirmed. We want Andy to continue the good work that is done in our community to the bench. And I'm here to answer any questions.
Many thanks for your statement. I see that there is at least one question for you. Representative Breckett, go ahead.
Hi. Good morning, Fatuma. I wish I could see you, but I can't because of the way that the system's working here. But I wanted to ask you, because I know what you do for work, because we've worked together in the past. I want to know your impression of your organization, I assume, is still providing cultural brokers for various organizations. Is that accurate?
Yes.
Yeah. So is that sort of informally what the role that you've played in part with the district attorney's office?
Yeah, so part of what we do is, and I know my friend Elizabeth is here, so I was trying to stay away from the gender-based violence thing, but we provide gender-based violence services. So that's sexual assault, domestic violence, trafficking, all that work. The piece that we did was we needed to have culturally specific gender-based violence that's comprehensive. And part of what we do is have this model that's called cultural brokering. So the cultural broker is an educator, an interpreter, a trainer, the liaison between the system and the recipient of the services. And so, yes, to this day, we do a lot of cultural brokering services. We do work with victims and survivors of victimization, all victimization. We have worked extremely very hard to not only do cultural brokering services, but also a very streamlined referral system. So for instance, if a victim, for instance, is not, they're not able, DA's office is not able to locate the victim, the cultural worker is called upon. You know, we go look for the victim, we go work with the victim, we go educate the victim. We have trained advocates. Our advocates do the 40-hour sexual assault training, 40-hour domestic violence training. Part of what they also do is cultural brokering services. And therefore, there's this robust way of working together, so much so that the victim is centered to, obviously utilize all services and be able to have the best outcome for the victim.
Thank you. When the legislature goes on break, I look forward to having lunch with you and Lewiston Auburn again. Thank you.
Lois is my representative record, sorry, is my my mentor, my biggest mentor. So thank you.
Thank you. Thank you for the question, Representative Reckitt. Committee members, are there additional questions? I am not seeing any. Fatuma Hussein, thank you very much for your statement today.
Thank you so much.
And then let's see, who else would like to speak in support of the nomination? If you could just step forward one at a time. Good morning.
Good morning.
Good morning.
Madam Secretary. My name is Zamza Mohamud. I'm from Hartford, Maine, Oxford County. Thank you so much for giving me this opportunity. And it's so hard to speak after Fatuma, but I'll try. Andrew is a kind, compassionate person. When it comes to his work, he is not only fair, but he's just. When I first met Andrew, I was clearly just how dedicated he was to his work. He went above and beyond. My interaction with Andrew of the community showed leadership, quality, experience, his professional ethics to the community and to the state of Maine. As a community member, Andrew always approaches, he's active, very good listener, and very valuable guidance to us, and his sense of justice. I can't just finish to say about Andrew in all this one meeting. Andrew always come to listen. We talk about things. We have a lot of where we immigrants from Somalia. We didn't know that laws in this country, and especially where we're coming from, the laws are totally different from it. But Andrew comes to all our meetings and explain to us the drug around the community, the violence around the community, and everything. And without that father, I will say Andrew have really welcomed us in the community and help us to understand the justice system for some of us to go back and explain to our community. And thank you so much, and I can take any questions.
Thank you very much. Committee members, are there any questions? I'm not seeing any. Thank you for your testimony today.
Thank you.
Are there others in the meeting room who wish to speak? Good morning.
Good morning. I assume I'm on.
You are.
Tell me if I'm not. My name is Woody Hanstein. I've been a lawyer, mostly in Farmington, for about the past 40 years. And I just thought I'd mention a couple things about Andy to you all, who I've known since he got to the DA's office over 20 years ago. The first thing is I'd like to talk to you a little bit about his teaching, because Andy's taken over the class that I started at UMF and taught for about 20 years. And the most annoying thing about Andy, or one of the most annoying things about Andy, is that I would have him in as a guest speaker to talk about the criminal justice system from the district attorney's perspective. and the class would enjoy it. And the next class, I would ask them about what they learned from Andy, and they would say, well, let's have him back. And you have him back again. And I didn't take affront, but it was, it was my class. It's like, would you guys rather hear from Andy than me? And, tactfully, they would say, well, we'd like to hear from him a little more if that would be possible. Similarly, when I got finished kind of winding down my affairs and law practice in Farmington, which is winding down now, that class was very important to me, and it taught UMF students a lot about the legal system. And I just didn't want them to lose that opportunity because it hadn't been offered before. So I asked Andy if he'd be willing to take it over, and he kind of jumped at the class. And the worst thing was when I told the people at UMF that I was leaving, but I was going to turn it over to Andy Robinson after 20 years of teaching. It was, geez, it's too bad you're leaving, but Andy Robinson, we're getting Andy Robinson. He really, his reputation, kind of preceded him at UMF and I think elsewhere. And the last thing, maybe on a more serious note, is in regards to that class, I would ask my students when we started talking about the criminal justice system, who's the most important person in the criminal justice system? When your 19-year-old nephew breaks into a garage and steals a lawnmower and he's caught on video and he confesses to that Class C felony burglary charge, who's the most important person in that young man's life? And they would usually start out and say, oh, it's the judge, because the judge can decide a sentence. And we talk about that. And then they say, oh, it's his defense lawyer. He needs to get a good defense lawyer. The better lawyer he gets, it'll work out better. And that's important too. But the right answer is the prosecutor, because it's a prosecutor you go to see. To the prosecutor who has an open and shut case on a felony charge that can ruin a 19-year-old life. And it's the prosecutor's discretion that keeps the world spinning on its axis in the best possible way. And I can tell you, in the 20 years Andy's been a district attorney, 20 plus years, I think I'm not exaggerating when I say I've handled more criminal cases in Franklin County probably than any other two lawyers put together. I have never once left talking with Andy where it wasn't abundantly clear to me that he was looking at things from my client's perspective. And I didn't always get what I wanted, but if I didn't get what I wanted, I understood why. And it was because Andy realized the felony, how damaging the felony would be to my 21-year-old or 22-year-old or 23-year-old, but he realized that just the need for the public to have that conviction overrode the importance to the person. You could not find a more fair-minded person, I think, to assume the position of a district court judge. And I think that the state's lucky for it. Thank you.
Thank you for your statement. Committee members, are there any questions? Don't see any hands
Okay,
up. Thanks
great.
for your statement today. Welcome.
Senator Carney, Representative Harnett, members of the Judiciary Committee. I'm Gordon Smith, a resident of East Winthrop. And as many of you know, I serve as the state's director of opioid policy in the state. I wanted to come and testify live today to support Andy, who I came to know just in this work. It's not been a lifelong relationship. I met him in 2019. I don't think there's much more that needs to be said today, but I wanted to share with you one of his qualities that really hasn't been even noted today, I don't believe, and that is his sense of humor. The first time that I met District Attorney Robinson was at a community event, substance use disorder conference in South Paris, sometime in our pre-pandemic life. I know it was in 2019. I know that Commissioner Sawchuk and I were there together and we were giving talks, but the district attorney was the moderator of the day. And we were in this building. I remember the public safety type building, could have been a fire station in South Paris. And I met him. And by the end of the day, I told him that if his career as a prosecutor took a dive, that he absolutely could get work as a stand-up comedian. He is he's hilarious. And I think in this day and age, for a judge to have a good sense of humor is almost as important as those other qualities that you've heard about today. I'll finish by just saying he's also very compassionate, and we've worked together to expand those our treatment and recovery courts, we prefer to call them now, to Franklin and Oxford counties, as he's mentioned, and we were able to find some state match money so that that could be done. I've been with him a dozen times since 2019, probably, usually in conjunction with some substance use disorder conference or this type of work. And he shares our passion for eliminating the stigma that individuals with mental illness and substance use disorder continue to suffer every day. So I was very alarmed when I learned that he was not running for re-election until later on it came to my attention why. And then I was delighted. He'll be a terrific district court judge, and I really appreciate the opportunity to be here today. I've been in this room for 45 years, and it's really good to be back. It hasn't changed a great deal, and I think your wonderful staff and behind the curtain has been here not nearly as long as I have. So thank you for the time. Be happy to answer any questions, and thank you for giving the district attorney every consideration.
Thank you. Committee members, are there any questions? Not seeing any. Thank you for your statement this morning.
Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Elizabeth Ward Sachs, so I'm submitting testimony today on behalf of the Maine Coalition Against Sexual Assault, the organization which represents Maine's sexual assault support centers, including Immigrant Resource Center of Maine, as well as Maine's Children's Advocacy Centers. I tuned in this morning at 9 and discovered you were doing a dual system here, and I just couldn't resist walking over to do this in person. And so I'm offering apologies for the first time in my over 20 years working in this building that I am wearing jeans. I apologize to the committee. I apologize to the institution. I apologize to everyone. When District Attorney Robinson called me to let me know his good news, my first reaction was disappointment, followed shortly by more generous emotions. You see, this is not my first rodeo. I remember similar calls asking to provide testimony on behalf of now retired or active judges Cantera, Fowles, Stokes, Rushlow. Over the last 2 decades, Maine's chief executives have an annoying record of recognizing excellence and elevating highly qualified individuals to the bench. While the judiciary has gained excellent jurists, Mikasa and our local providers have lost extraordinary community partners. Sure, we occasionally see them on the bench or representing the judiciary on some working group or whatever, but mostly they disappear from our lives. And here we are again. But DA Robinson made me promise not to lean into my earlier reactions or to lean into my later reactions and not maybe hold back a little bit on the disappointment. And so I'm going to make a good faith effort to do that. On a more serious note, the Maine Coalition Against Sexual Assault and the victim service providers we represent believe that District Attorney Andrew Robinson is an excellent choice for the bench. Today, you've heard directly from one of our members, the Immigrant Resource Center of Maine, but our other Tri-County service provider, Sexual Assault Prevention and Response Services, wanted to share the following. First, from their executive director, Megan Davis, who said, in supporting victim survivors of sexual violence, Andrew Robinson has been an integral part of their justice and healing journey. His victim-centered approach and dedicated priority for community collaboration has been revitalizing. Andrew's leadership and integrity has motivated anti-violence work in a direction that provides inclusive, unbiased, and trauma-informed care for those victim survivors navigating the legal system. And from Kat Perry, their Children's Advocacy Center program manager, who shared, Andy Robinson has been a champion for children within our joint collaborative and cooperative response to child abuse cases within our region of the state. He is very trusted, respected, insightful, and intuitive partner who knows how to find the diplomatic means necessary for the most optimal outcomes for both service providers and on behalf of those impacted by violence. I've had the pleasure of working closely with DA Robinson for well over a decade, first occasionally when he was an ADA and more regularly once he was elected as DA. We have shared space at numerous statewide policy tables, including here in this building, and I have sought his advice on critical issues more times than I can count. As a result of what I've observed in these settings, he exemplifies the American Bar Association's key criteria for evaluating judicial candidates. Specifically, I can attest to his integrity, legal knowledge and ability, judicial temperament, diligence, and public service. I'm fortunate to have many examples which illustrate these attributes, but I'm going to restrain myself and focus only on a couple. In March 2018, MICASA convened an advisory committee and contracted with the Muskie School of Public Service to conduct a statewide study on sex crime forensic evidence exams in Maine. This is the fun kind of work that MICASA gets to do. The goals of this study were to gather comprehensive data about the status of sexual assault kits, to highlight successes and challenges relating to processing and storing these kits, to research national best practices, and to make recommendations for systems improvement. DA Robinson agreed to serve on the advisory committee representing Maine's prosecutors. The study revealed many issues related to kits, including that 39% of law enforcement surveyed reported that during the last year, cases involving kits were rarely or never reviewed by a prosecutor, 39%. And 76% of prosecutors surveyed believe that law enforcement should always notify them when the kit had been collected. 39, 76. Best practice in reducing bias related to which cases move forward and which do not requires multiple sets of eyes on evidence and eyes with different expertise. And so the report made a recommendation to develop and implement a statewide model policy for prosecutorial review of all sex crimes cases involving kits. The law enforcement member of the advisory committee felt strongly that a model policy was not enough, that we needed a statute to require that in all cases that involve a kit should be reviewed by the DA. I was worried about the impact these reviews would have on our already strapped DA's offices. But I also knew it would be in the best interest of survivors. Then DA Robinson spoke up. To paraphrase, he said, "If we're worried about bias in sexual assault cases, why would we limit case reviews to only those sexual assault reports which involve rape kits?" I was stunned. Of course, he was right, and it would result in a significant increase on the burden of his and other DA's offices. Today, Maine law requires that law enforcement inform the DA of any reported sexual assault under Title 17A, Chapter 11, and provide the evidence for DA's review. This is a statute which has resulted in real and lasting benefit for survivors. I often think about what I want for survivors of sexual violence who find themselves in court as either plaintiff or defendant, because we know survivors sit in both chairs. The first item on my requirement list is an exemplary legal knowledge, which is not a given, as we sometimes see judges make decisions based on unfamiliarity with all the complex statutes and case law which apply to sexual violence. Having watched DA Robinson stand and deliver, I know he checks this box. I would also hope for a truly open mind. I've watched DA Robinson and ask questions, think critically about the criminal justice system, as you've heard a little bit before with his class on criminal justice reform and its impacts, and the ways in ways that might seem counter to what you might expect from a district attorney. But on the same level of importance on my list is demeanor. Sexual assault survivors, again, regardless of which chair they're sitting in, are engaged in some of the hardest moments of their lives. And on top of that, are in an unfamiliar and often quite public setting. And so I think about the tone that's set by the judge. If you know Andy Robinson, you know that he is a person who puts others at ease. He's kind and welcoming. He's exactly the kind of person I would want to be facing on the bench. We thank the governor for this nomination and urge you to confirm District Attorney Andrew Robinson to Maine's District Court bench. Thank you for your time and consideration, and I'd be happy to answer any questions you might have.
Many thanks. Committee members, are there any questions? I'm not seeing any.
Thank you.
Is there anyone else present in the committee room who wishes to speak in support of this nomination? I'm not seeing any, so now we'll turn to those who are in the attendee portion of the meeting and ask that anybody here who wishes to speak in support of this nominee, please raise your electronic hand and keep it raised until you've been brought onto the panel and provided your testimony. And I think we will first hear from Cumberland County DA Jonathan Sarbeck.
Good morning, Senator. Good morning, Senator Carney, Representative Harnett, members of the judiciary. Thank you very much for having me. I'm Jonathan Sarbeck. I'm the district attorney here in Cumberland County. I know you've already heard from DA Maloney with regards to the MPA sentiments, which I completely echo. But I apologize I couldn't be there in person, but I just, from a personal standpoint, wanted to voice my support for the nomination of DA Robinson. I can tell you, though, that didn't come easy, because I figured if I got up here and slammed the podium and said, no, 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 that you guys wouldn't confirm him, we could keep him as the district attorney in Androscoggin County. But I know that that would just be selfish on my part, and it wouldn't be beneficial for the people of the state of Maine, because with this nomination, you're going to get a very intelligent, hardworking, passionate, compassionate, and practical judge for the district court. I think that it's completely fitting, and I'm glad that I went sort of later in the order, because when you have prosecutors, defense attorneys, people who act in a teaching capacity, advocates from the community, advocates for substance use disorder, and advocates from the domestic violence world, all speaking in the same voice in support of a nominee, I think it right there is plain to me that this person is fit perfectly for the job. And that's what you've had this morning with the nomination of DA Robinson. He's intelligent on the law, like you've heard. He's practical when it comes to making things better. And he's always passionate for justice. And for justice, I mean, doing what's right, doing what's fair for everybody involved in the system. And it's something that he's been a go-to for me when I need advice or I need to run something by him. And I found out on Friday that he wasn't just a go-to for me, but it's go-to for many of the DAs across the state. And so we're all going to be kind of leaning on each other in his absence, but we're okay with that. And the last thing I just will say about DA Robinson is one of the things that I admire about him, and I think that it's what he's brought to his office, and from what you've heard from members of his own community, is that he doesn't settle for the idea of that's how we've always done it. He pushes it and he tries to say, well, we can do it better. And that's one of the things that I think is the most admiring quality that I see in him. And one of the many reasons that I think that he's going to be a terrific district court judge. And I would urge you to support his nomination. I'd be happy to answer any questions.
Thank you very much. Committee members, are there any questions? Not seeing any. Thank you for providing your statement this morning.
Thank you.
Next, we'll hear from Susan Fonts. Welcome.
Good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Susan Fonts, and I am the president of the Maine Trial Lawyers Association. I reside in North Yarmouth. I am here today to testify on behalf of the Maine Trial Lawyers Association. As I stated last week, when we have these judicial nominations, we conduct a survey of our membership to receive feedback about the particular candidate. We test the candidate in areas such as their skill, competence, and demeanor. Here, we received positive responses for District Attorney Robinson. Members of our organization stated that he was high as to his skill, competence, and temperament. Survey respondents who did have experience interacting with District Attorney Robinson testified that he was intelligent, fair, and unbiased. People also described him as smart, so fair, and equitable. In reviewing his nomination, our leadership noted that he has extensive experience both as a prosecutor and as a private attorney. So based on these high evaluations, the Maine Trial Lawyers Association endorses his nomination, and we believe that his continued service in the district court will bring honor to the judicial branch. Thank you.
Thank you very much. Committee members, are there any questions for Susan Fonts on behalf of the Maine Trial Lawyers Association? I'm I'm not seeing any. Appreciate you being here today. And then finally, we will hear from Walter McKee.
Good morning or good afternoon. Senator Carney, Representative Harnett, members of the Committee on Judiciary. My name is Walt McKee. I'm a resident of Hollowell. I'm a private practice attorney here in Augusta. I want to thank you for the opportunity to speak on behalf of Andrew Robinson in support of his nomination for the position of District Court Judge. I fully and completely support the nomination. I've known Andy for my entire career, and early on in my practice, I started handling cases in Farmington. That's when I first met Andy. It was clear from the start that Andy was not only a very talented and intelligent prosecutor, he was also very fair to deal with. When I worked with Andy on the other side, with him as a prosecutor, myself as a defense lawyer, I knew that he would always be open and upfront in his dealings. When Andy said something, you could really take it to the bank because you knew that he was a person of his word. And integrity really means everything in the practice of law. And Andy's integrity is unmatched, but perhaps even more importantly, Andy has always had a great deal of humanity in dealing with all the many cases we see in the criminal practice that involve people who have often made tremendous mistakes. As I often say, many defendants in criminal cases are just ordinary people involved in extraordinary circumstances. And Andy never lost sight of this when he handled the case. And I have distinct memories of cases I've had over the years when I've seen that Andy was the assigned prosecutor to the case. And I thought, well, this is Andy's case, great. Andy will get it. And when Andy was elected as DA for Androscoggin, Franklin, and Oxford counties, I was pleased, as were many of the attorneys I spoke with at that time. He's been an exceptional leader as a district attorney, not only in managing a really fine group of ADAs and staff, but as a really forward-thinking prosecutor who's always been unsatisfied with the status quo, consistently willing to look to ways to improve our system of criminal justice. Andy's work in implementing the electronic transmission of discovery materials was a real game changer. With his leadership in providing police reports, statements, and everything that must be provided by the DA's office to a defendant, the entire state now has a system where discovery materials can be quickly and thoroughly provided, and saving untold staff time, equipment costs, and eliminating what had really been a highly inefficient system almost overnight. And that was the case in every single district attorney's office throughout the state. That system was terrible. And even though this is an improvement, I think that we all can agree, and I'm sure Andy would agree as well, that there are still improvements to be made to that system, but it's significantly better. And it was because he made it happen. And because being a judge is often more than just judging and regularly involves improving the judicial system to make it more efficient, Andy's experience and his can-do attitude will be invaluable. Now, I want to be crystal clear at this point. Over the years, I and many have been concerned about the number of prosecutors that have gone to the bench. In prior administrations, a substantial number of prosecutors became judges, so much so that the number of judges now that have been prosecutors before becoming judges represents a significant percentage of the bench. But when Andy expressed interest in becoming a judge, I fully and completely supported it. And I do so now without any reservation. Governor Mills has done an exceptional job in nominating a diverse group of attorneys, and nominating Andy with all of his prosecutorial experience is simply part of that thoughtful nomination process that aims to bring great lawyers to these significant positions. Now, that was most of what I wrote in my statement that's been provided to you, but I wanted to take another tack here as well, which I think is very important, because we've heard almost entirely about Andy's work as a prosecutor, the things he's done as a prosecutor. And that's all well and good. But as those of us who work in the system know, the work of a district court judge, the work that Andy will do, will be about 10 or 20% in the criminal justice system. There's that whole 80% that Andy may have touched on early in his practice, but he hasn't done a lot of. And that's what happens when we have district court judges. They don't really have subject matter experience in all areas. And so they're really untested. But the reason that we nominate people like Andy to the bench and have them on the bench is because they have a sense of justice. In my view is that if they have a sense of justice, I almost don't really care about what experience they have, what they've done over the past 20, 30 years of their career. If they have a sense of justice and a sense of humanity, then everything else kind of takes care of itself. And I think that's exactly what's going to happen with Andy, who probably hasn't had a small claims case, a divorce case, a child protective case, a contract case, all of that other work that's done by district court judges day in and day out. But what I do know is that given the person he is and his sense of justice and humanity, that he really will be a great judge. And I support his nomination, and I'm happy to answer any questions today. Thank you.
Many thanks for your statement. Committee members, are there any questions? We do not have any questions. Thank you. And so we've heard, I believe, from all those who wish to speak in support of this nomination. Is there anyone in the room or who is an attendee in the electronic meeting who wishes to speak in opposition? I am not seeing any. Is there anyone who wishes to be heard before we conclude the hearing? I am not seeing any hands up. Thank you all. All public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee. We will vote on the nomination and notify the President of the Senate pursuant to Title III MRSA Section 157 and the joint rules. The vote must be taken within 40 days from the governor's written notice, and we are within that time frame. The hearing by the Joint Standing Committee on Judiciary for Mr. Andrew S. Robinson, Esquire of Farmington for appointment as District Court Judge is closed. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, the chair will inquire as to whether any member present objects to the taking of the vote immediately. Committee members, if you have an objection, could you please raise your real or electronic hand? I do not see anyone raising a hand in objection. Therefore, we will proceed to the vote. The pending motion before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Legislature that the nomination of Mr. Andrew S. Robinson, Esquire of Farmington for appointment to as a District Court Judge be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of confirming the nomination. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? It appears that we are. The clerk will call the roll.
Thank you, Madam Chair. Representative Galgay Reckett,
Yes.
Representative Galgay Reckett votes yes. Representative Newell,
Yes.
Representative Newell votes yes. Representative Evangelos,
Got to get that microphone on. Yes.
Representative Evangelos votes yes. Representative Poirier,
Yes.
Representative Poirier votes yes. Senator Kine, Senator Sanborn, Senator Carney,
Yes.
Senator Carney votes yes. Representative Harnett,
Yes.
Representative Harnett votes yes. Representative Babbage,
Yes.
Representative Babbage votes yes. Representative Thorne,
Yay.
Representative Thorne votes yes. Representative Sheehan, Representative Moriarty,
Yes.
Representative Moriarty votes yes. Representative Hagan, Representative Libby,
Yes.
Representative Libby votes yes. I will recall the absentees. Senator Kine. Senator Kine is absent. Senator Sanborn. Senator Sanborn is absent. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent. Madam Chair.
Thank you. 10 members of the committee having voted in the affirmative and 0 members having voted in the negative. It is the Joint Standing Committee on the Judiciary that the nomination of Mr. Andrew S. Robinson, Esquire of Farmington for appointment as a District Court Judge be confirmed. Congratulations. And we are delighted to be able to thank you in person, but there's a bigger committee than those of us in the room, so we'll start with a virtual round of applause. for you. Thank you. And committee members and those members of the public who are listening, we will be in recess until our 1 o'clock confirmation hearing on the Honorable Amy Faircloth. Thank you, everyone.
Representative Harnett, I didn't know if you knew that your camera was on.
on your video as soon as you're back. Thank you and welcome. We're just waiting for committee members to return from recess. We will start up in a couple of minutes. Sure. Steve was coming back, right?
Yeah, he
Okay.
is coming back. He just went out to put together.
Okay. Again, committee members, as you return, those participating remotely, please turn on your video so I know that you are with us in a manner of speaking.
Jim.
I'm gonna not use this because it's keeps locking up. Thanks. Thank you.
Still something. You're still here.
Am I still there?
I just tripped on and stopped it.
Okay. It should be off.
Now it is.
Great. So 1, 2, 3, 4, 6, 7, 8. Oh, okay, 9. How do you see? 1, 2.
8. We've got it.
You got 8. Okay. Good afternoon and welcome to the Joint Standing Committee on Judiciary. For our final nomination of the day, we will be taking up the nomination of the Honorable Amy L. Faircloth of Bangor for District Court. But I'm going to have committee members introduce themselves since many of you were not here with us in the morning when we did that. And I'm going to begin with those participating remotely, and I will call upon them in the order that they appear on the big TV screen. Representative Babbage.
Thank you, Mr. Chairman. My name is Christopher Babbage. I'm in my 6th term in the legislature, my 3rd on this prestigious committee, which I'm very proud of. And I represent House District 8, which is most of the town of Kennebunk.
Thank you, Representative. Representative Galgay-Reckett.
Good afternoon. My name is Lois Reckett, and I represent District 31, which is the ocean end of South Portland.
Thank you. Representative Poirier.
Thank you, Mr. Chair. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you. Representative Thorne.
Thank you, Madam Chair. Pardon. Thank you, Mr. Chair. My name is Jim Thorne. I represent House District 103, which are the towns of Carmel, Herman, and a portion of Etna up in beautiful Penobscot County.
Thank you, Representative. Representative Newell.
Thank you, Mr. Chair. Good afternoon, everyone. My name is Rena Newell, and I serve as the Passamaquoddy Tribal Representative.
Thank you. Representative Moriarty.
Thank you, Mr. Chair. I am Steve Moriarty. I represent my hometown of Cumberland and part of Gray. Together, they make up House District 45.
Thank you. And Senate Co-Chair Carney.
Thank you. I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, where I live, and a little bit of Scarborough.
Good afternoon. My name is Tom Harnett. I serve as the House Chair. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside. So we will open our public hearing. This is a public hearing of the Joint Standing Committee on Judiciary for the purpose of considering the nomination by the governor of the Honorable Amy L. Faircloth of Bangor for appointment as a district court judge. Today's meeting is being conducted using a hybrid format. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, Senator Carney and I will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have the opportunity to question the governor's representatives, the nominee, and all other persons present who wish to speak for or against the nomination. Before we get started, I want to share some information related to the fact that this meeting is being conducted using a hybrid format. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is participating via Zoom can be seen and also heard if their microphone is unmuted. People testifying via Zoom cannot be seen or heard until they are called upon to speak. The meeting will be recorded and available to view on the committee's YouTube channel shortly after we finish our work for the day. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Poirier for the purpose of making such a motion.
I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Amy L. Faircloth of Bangor for appointment as District Court Judge.
Thank you, Representative Poirier. Do I have a second? Seconded by Senator Carney. The statutory requirements for this position are posted on the committee's webpage. At this point, I'm happy to recognize the Governor's Counsel, Jerry Reed, for the purpose of making a statement concerning this nomination.
Thank you. Good afternoon, Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Jerry Reed. I'm counsel to Governor Mills, and it's a pleasure for me to be here this afternoon to ask for your support for the governor's nomination of Amy Faircloth for appointment as judge of the Maine District Court. Amy Faircloth began her impressive legal career with several clerkships, including in the superior courts of both Alaska and Maine. She then joined a respected Bangor firm where she practiced for 7 years in the areas of family law, criminal law, insurance defense, and estate planning. In 1995, she co-founded her own firm in Bangor, focused on civil litigation with a particular focus on family law, where she worked for 24 years. During that period, she also served for 3 years as the Penobscot Nation's child support enforcement attorney in tribal court. In 2019, she accepted a position as a full-time professor of legal studies at Husson University, while at the same time becoming Penobscot County's probate court judge. She's a graduate of Claremont McKenna College with a degree in American Studies and earned her JD from the University of California's Hastings College of Law. Amy Faircloth's career represents ideal preparation for a position on the district court. She has decades of trial court experience, including in criminal law and particularly in family law, the subjects that are at the heart of the district court's jurisdiction. She has also served for 3 years as County Judge of Probate, introducing her to the judicial role and the unique challenges that come with it. She's a highly regarded member of the Bangor Bar who has the trust and confidence of the legal community. On behalf of the governor, I respectfully request your support for the nomination of Amy Faircloth as judge of the Main District Court, and I'd be happy to answer any questions that the committee may have of me.
Thank you, Counsel Reed. Are there any questions from committee members for the governor's counsel, Jerry Reed? Not seeing any. Thank you very much for bringing this nomination forward and for being with us this afternoon.
Thank you.
I will next recognize John Hobson, the chair of the Judicial Selection Committee.
Thank you very much.
Welcome, Mr. Hobson.
Thank you very much. Representative Harnett, Senator Carney, members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I'm Chair of Governor Mills's Judicial Selection Committee. On behalf of the committee, I request this committee support the nomination of Amy Faircloth to the Main District Court. The list of accomplishments that Mr. Reed related to the committee have already been set forth before you. What is a little harder to set forth before you, but for you to understand, is the reputation that Ms. Faircloth enjoys in the Bangor Bar and the Bangor community. She certainly has the extensive experience in the subject matters that most of the subject matters the district court deals with. And she's done that over the many years with this really the support of the entire Bangor Bar. It's unusual when you get a nominee who has the support of all spectrums of the practice. And that's true for Amy Faircloth for the Bangor and Northern environments. Also, kind of as a testament to that, she's what currently exists as one of the few elected judges positions in this state. And as Mr. Reed said, she's already been introduced to the judicial world. Now, it's not the Main District Court, but it has many of the same aspects. And one aspect of her performance as a probate court judge that I think really does relate is that among the practitioners of that court is she's really speeded things up. She's really been able to make that court more efficient and really been someone who's been able to bring some efficiency to the docket. Those attributes are always welcome, in fact, important in terms of a district court judge. She's had the preparation for, gotten the support and really admiration of her peers, and has shown through experience in a different court, but certainly a court of significant jurisdiction, that she has the ability to make decisions and have the docket move. She will be someone who will be a tremendous asset to the Main District Court and will serve the citizens of the state of Maine of her regions well. So on behalf of the committee, I request that this committee support her nomination. Of course, I'm more than happy to answer any questions.
Thank you very much, Mr. Hobson, and thank you for the work that you do with the Judicial Selection Committee. Are there questions from committee members for John Hobson? I am not seeing any. Again, thank you very much for bringing this matter forward. I will now recognize the Honorable Amy L. Faircloth to welcome her to the Judiciary Committee and recognize you for the purpose of making a statement concerning this nomination. Welcome.
Thank you. Senator Carney, Representative Harnett, members of the Judiciary Committee. I'm honored and humbled to have been nominated by the governor to be seated as the Main District Court Judge. I thank the governor for her confidence in me, and I thank you, Attorneys Hobson and Reed, for your kind introductions. I'm honored to appear before this committee seeking confirmation as Main District Court Judge. But first, I want to take this opportunity to thank you all for your service to the people of Maine. My name is Amy Faircloth. I've lived in Bangor with a brief stint in Hamden since 1987. I was born in Brooklyn, New York, and raised on Long Island. My father was a certified public accountant and taught accounting at City College. I loved nothing more than to help him grade exams with a red pencil. He always thought I would be a judge, and I'm sorry that he is not with us today, having passed in 2015. My mother was a registered nurse with all the attributes of that profession: nurturing, caring, and very sensible. I have two siblings. One brother and his family live in North Carolina. My sister has recently moved to Bangor with our mother, who has dementia. I cannot thank my sister enough, and she's with me here today, one of my support sisters. I'm the mother of Brendan, who's 30, and Ryan, who's 28. Brendan lives in Bangor with his partner, Allison, and my granddaughters, Mariah and Caitlin, ages 9 and 8, to whom I am Mimi. Ryan has his master's in clinical psychology, which he recently received from the University of London. He lives in England, working on construction of an underground high-speed train from London north. I graduated from Claremont McKenna College in Claremont, California, with a degree in American Studies and received my law degree from the University of California, Hastings College of the Law in San Francisco. It was at Hastings that I began to think about the type of lawyer I wanted to be. Much to my surprise, I discovered I liked litigation. My favorite classes were mock trial and civil litigation, as well as constitutional criminal issues. I clerked for the California Court of Appeal and found myself fascinated by the trial process as I read transcripts of the trials being challenged on appeal. I began to then see myself as a litigator. Then I volunteered at the Tenderloin Housing Clinic. Hastings is located in the Tenderloin district of San Francisco, home to a large population of folks who are homeless and living in extreme poverty. There are numerous nonprofit social service agencies in that district, such as soup kitchens, rescue missions, and homeless shelters. The Tenderloin Housing Clinic offered important social services to that neighborhood and still does, recently acknowledging its 40th year anniversary. I worked to help get and keep people housed. As a law student, my job was to interview and do initial intakes. This introduction to people who literally lived on the streets convinced me that I wanted to help people who were otherwise marginalized. Soon thereafter, I worked for Alaska Legal Services, which, just as an aside, as you know, I was here during Mr. Robinson's presentation. Who would have thought you would have heard Alaska mentioned in both of our presentations? Anyway, I worked for Alaska Legal Services in the small native village of Bethel in Southwest Alaska. I met with Yupik tribal members regarding multiple civil issues, including family matters, social security, estate planning, and welfare benefits. My first experience with a general private practice was in Fairbanks, Alaska. This experience with a solo practitioner convinced me that this is what I wanted to do. He did it all: divorces, adoptions, wills, criminal matters, car accidents. I typed for him, met with clients, drafted pleadings, and went to court. Every day was different. Every day I got to talk to people, and every day I was helping people. After graduating from law school, I took a job working at the trial court in Kenai, Alaska, which is a beautiful peninsula south of Anchorage. I served as the presiding judge's law clerk, helping to keep track of his calendar, writing memoranda summarizing upcoming trials and arguments, and drafting proposed orders. Alaska is a beautiful state. I just didn't want to live there on a permanent basis. I wanted to be closer to my family here on the East Coast. So in November 1986, I interviewed with Judge Brody just down the road right here in Augusta, the old courthouse. I had never been to Maine before, legit. I had never been to Maine before I interviewed with Judge Brody. Those of you that know Judge Brody, he was inspirational and very persuasive. Maine, even late in the day in November, was beautiful. So he offered me a job. He offered me the job as a law clerk for the Maine Superior Court, either in Kennebec County or Penobscot County. We visited both courthouses and fell in love with the mural in the Penobscot County Courthouse building. Okay, so that was our decision. Penobscot County it would be. Funny how we make decisions in life. For several months before I started working for the court system, which I did, I had the privilege of working for George Singal, Lou Kornreich, and Jules Mogul. I would not have asked for a better introduction to the Bangor legal community. After serving a year as the law clerk for the Penobscot County Superior Court, I began work as an associate for Vafiatis, Furness, and Kaminsky. Once again, you could not ask for better role models. Attorney Louis Vafiatis was the lawyer's lawyer. He was the ultimate gentleman, known not only for his legal skill, but for his collegiality with the bar and with the bench. Attorney Marvin Glazier was the people's lawyer. He turned no one away. In other times, Marvin would have been the lawyer who accepted pay in chickens. His clients loved him. The adverse parties loved him. Attorney Susan Kaminsky helped pave my way, and many like me, as a woman attorney in Maine. I'm forever grateful to all of them. My legal goals were being met. I was trying cases and I was helping people. It's difficult to summarize my practice with them. I worked there for 7 years doing all types of cases, including criminal misdemeanors and felonies, divorce, insurance defense work, plaintiff personal injury cases, medical malpractice defense, child protective matters, and administrative hearings for child support and driver's license revocations. I appeared in the multiple courts around the state, mainly Augusta North. I wrote and argued appeals to the law court. I was utilizing my legal education and skills to meet with people and help solve problems. In 1995, Dawn Pelletier and I partnered up and started Pelletier and Faircloth. We were a general private litigation firm. Criminal matters, workers' compensation, personal injury cases, insurance defense, and family matters. As my reputation grew, I began to focus primarily on family matters. I served as guardian ad litem in cases, and I contracted with Penobscot Nation as their child support enforcement attorney for several years. Audrey Bracchio later joined our firm as an associate, and then in 2016, we formed the partnership Pelletier, Faircloth, and Bracchio. So for 25 years, I spent my days working with individuals to solve problems and appearing in district courts, probate courts, and tribal courts. I have been so fortunate to have had a career doing something I love to do with people I like to be with and helping people through difficult emotional and financial times. My partnership with Dawn changed my life for the better. Not only was she my partner, but she was and continues to be my mentor, my sounding board, and my friend. Thank you. It's not easy to run a business, take care of my clients, and raise my sons at the same time, but I would not change a thing. I think that part of my success as a family lawyer was that my clients could relate to me and me to them. I too learned to co-parent as in the best interests of my children, and I would like to thank Sean for parenting with me. I too have learned to advocate for my son who is on the autism spectrum. As an example, there is an insurance program through MaineCare called Katie Beckett. That program provides medical coverage to eligible children with special needs, regardless of the income of their parents. No medical care provider had ever told us about this program. Instead, I learned about it from other parents. I struggled, along with many other parents, to figure out what would be best for our son. Now, I'm so proud of both my sons and the men they have come to be. I am proud of the work I did as a private practitioner, and I am proud of who I am today. Where I am today would not be complete without talking about the Bangor Humane Society and the school board of RSU 22. After representing the Humane Society in a probate matter, I joined the board. My more than 10-year commitment to the Humane Society included volunteering Saturdays as an adoption counselor, fostering wayward dogs, serving on its executive committee, and ultimately as its president. In 2011, I ran for my local school board. Now, I have no doubt that local school systems intend the best for our children, but it's important for parents to advocate for their child. It took me many years to find my voice on behalf of my son. I felt marginalized and an unimportant member of my son's education team. As a result of that experience, I ran for school board to draw attention to special education services and to help set policy for parents who found themselves in similar situations. I served on the school board for 3 years, resigning only as I moved back to Bangor from Hampton. In 2018, I was elected probate judge for Penobscot County. Soon after, I accepted a position at Husson University in the Legal Studies Department and retired from Pelletier, Faircloth, and Braccio. I thus began my career as a part-time probate judge and an assistant professor at Husson, teaching a full load of classes each semester. Before I talk about my experience as probate judge, I would like to address my students who may be viewing this confirmation hearing on YouTube. Now, for you folks to know, I did not require them to view this confirmation hearing, but I believe some of them may be watching. And to you, my students, it has been one of the joys of my life to have shared my knowledge of the law with you and to have learned from you. If I'm lucky enough to be confirmed, I will miss you all terribly. I'm gonna cry, but I will look forward to seeing you appear in front of me as lawyers, legal assistants, and law enforcement officers. And when things get complicated, remember to take it slow and break it down. It has been an honor to serve the people of Penobscot County as probate judge. I'm delighted at this opportunity to continue as a judge full-time for the state of Maine. I find great satisfaction being probate judge. Probate courts in Maine hear matters of critical importance. We hear cases involving the care and welfare of children, as well as the care and welfare of adults who lack decision-making capability. On any one day in court, I will be talking to an 18-year-old with developmental disabilities, a 13-year-old whose parents have both passed, a 90-year-old who only wants to drive his car again, and adult siblings who are fighting over the family home. On any of those days, I seek to fashion an order in accordance with law and that protects the individual as well as constitutional due process rights. I work extensively with pro se litigants, educating them on the law, seeking a resolution that works, and making decisions that enable them to move forward in their lives. I would have a lot to learn as a district court judge, and I understand it would be a great challenge. The district court jurisdiction is broader than that of probate court, and the cases come at you fast and furious. I am humbled by the road ahead of me. I am excited about that challenge. I look forward to the opportunity to work with the jurists, staff, and lawyers throughout the state. I was led to litigation so that I could help people. I believe I can be of service to the people of Maine in this new role as district court judge, and I respectfully request that you confirm my nomination. And I'd be very pleased to answer any questions you might have. Thank you.
Thank you, Senator Carney. Thank you, Judge Faircloth. Thank you for your service to the state and congratulations on this nomination.
Thank you.
Are there questions from committee members? Representative Thorne.
Thank you, Mr. Chair, and welcome Judge Faircloth. Congratulations on your nomination for District Court Judge. And to say that you have an impressive and extensive background and experience would be the understatement of the day. And I had to share with you that Anchorage, Alaska was my first assignment at 18 years old in the Air Force. So I got to experience Alaska and all its beauty and glory for a few years, from the Iditarod dog sled race to Mount McKinley, and actually did get a chance to go up to Fairbanks, and quite the beautiful country. My question for you is, I know, and you've addressed it, but 99%, I believe is what I read, were civil cases that you have gone before you. And I guess I would just be interested in knowing a little bit about how your approach to more criminal matters and how that would, you believe that would vary.
When I answered that question on my application, which I believe is what you're referring to, and thank you for that question, I'm not sure that I was thinking about my whole overarching career, because certainly my overarching career would include a lot more criminal cases than that. More recently, since 2000, I don't think I've done a criminal case since 2000. Prior to that, though, I did have some extensive experience in criminal matters. Some of them I mentioned in my application. I certainly worked with Attorney Glazier frequently on motions to suppress and misdemeanor trials. And then with Attorney Vafiatis, we had several highly visible cases, criminal cases that I would be preparing along with him and doing jury trials. So the 99% does not include my overarching percentage, if you will, of criminal versus civil cases. And in terms of where I am today with respect to my knowledge of criminal matters, I just want to take myself back to my start as probate judge when Title 18A was in effect. And 9 months later, Title 18C became in effect. So I had to learn the two different statutory schemes. And so I buckled down, and that's what I did. And that's what I would do with respect to the criminal matters as well, is review Title 17A. And my colleagues on the bench and in the bar have generally been very helpful to me if I have any questions about anything. And as probate judge, I frequently talk to other probate judges as well as district court judges when I'm running into something where I have a question about. So I anticipate that that's what I would do in the criminal field as well.
Thank you. And on behalf of the Penobscot County Legislative Delegation, thank you for your past service in the probate courts, and congratulations on your nomination and best of luck. And I know Representative Hagan, who is an educator in Hamden, will be sorry that he missed your nomination process confirmation, but on behalf of him and the entire delegation, congratulations and best of luck on your pending confirmation.
Thank you so much.
Thank you, Madam Chair.
Thank you, Representative Thorne. Representative Galgay-Reckett.
I have a welcome, Judge Faircloth, and I have a sort of a puzzling question to ask you, not about your own practice of law, but what you believe, a circumstance I want you to analyze for me. Can you think of one or more circumstances in which you might, in a divorce case, alleviate the responsibility of child support from a father who has 3 children and has left them and the mother to fend for herself? Is there any circumstances you can figure out where that might be appropriate?
Thank you for that question, Representative Reckett. As you are probably aware, the child support guidelines in Maine provide for various kinds and types of deviations. This sounds like one of the questions that I would ask my students in my family law class is, how would they handle this situation? And what they would probably say to me is, it depends. Those kinds of questions are very fact specific. You've given me some facts here. You've told me that the father is of 3 children. You've told me that he has left the family and that the mother is able to support herself, I assume, and the 3 children. Those would be factors that that's what I thought I heard you say. If those were the factors.
Yeah, I know.
I'm sorry.
No, that is what I said, but that doesn't happen to be the facts, but that's what I did say. So feel free to continue to respond.
So those are factors that I would take into account and would match to the law as indicated in the child support guidelines, but certainly would consider what would be fair and what would take care of the children. I understand the state's priority is to make sure that our children are financially taken care of. So that certainly would play a large part in my consideration.
Thank you. Could I ask one more question?
Yes, you may.
Chairman?
Yes, you may.
Is it possible that your experience as a GAL would color your work in this arena of family law?
I believe that, I'm sorry?
Or inform your work, sorry, inform your work, not color your work.
I believe that all of my past experiences color the way that I would approach any of the cases in front of me. Certainly, I have done a lot of guardian ad litem work. I certainly have focused my attention as guardian ad litem on the children's best interest. And ultimately, that is what I will look out for, all within the constraints of the law, though, of what statutory and precedential law require me to be. So the short answer is yes, I believe that my role as guardian ad litem in the past would certainly inform how I act as a judge. Yes.
One last quick thing, please give your husband my regards. I haven't seen him in a long time.
I will, thank you.
Thank you, Representative Reckett. Representative Moriarty.
Thank you, Mr. Chair. Judge Faircloth, I have this compelling need to ask you whether your students refer to you as Your Honor.
Yes, so thank you for that question. When I first started teaching, so I'm completing my third year there, that question was asked of me a lot. And so my response would be, I'm here at Husson, you can call me Professor Faircloth. If I ever see you in court though, you need to call me Judge Faircloth and Your Honor.
Good answer. Tell us just a bit about your academic career. What courses do you tend to focus on? Is there a clinical practice involved as well?
What do I teach?
Yes.
Yeah, so I am fortunate enough, lucky enough to teach a broad range of classes, and there's 8 of them that I teach. I won't necessarily list all of them. I teach Intro to Legal Studies, where I get to talk to them about the various substantive issues of law, so tort law, property law, probate law, get to talk to them about that. And what I love to do the most in that class is bring in real life situations. And we'll say, look, here, hey, I don't know if you remember, there was the person that sawed a garage in half in Piscataquis County. So here we've got a Piscataquis County case that sort of was infamous, if you will, talking about tort law and property law. So I'd love to bring that kind of information in. So there's Intro to Legal Studies. I teach 2 legal writing classes, which has been instrumental in helping me hone my writing skills. Many of you probably know that you learn best by teaching somebody else something, and that has actually been the case for me as well. Right now, I'm teaching constitutional law, and they are learning about the 5th and 6th Amendments. So talking about the rights of defendants. I've been so lucky to be able to teach just a broad range. I do teach probate law as well.
Sure.
Yeah.
Good. Thanks very much.
Thank you.
Thank you, Representative Moriarty. Representative Babbage.
Thank you, Mr. Chairman. Hello, Judge Faircloth. It's wonderful to see you again, and especially on such a momentous occasion. Thank you for offering such detail in your application and in your opening statement. I was impressed that you served on the school board. That seems to be a more challenging assignment as time evolves here. Really, what I was interested in, you had various experiences in Alaska, and you also worked with the tribal court here in Maine. I wondered if one influenced the other, and could you just elaborate a little bit about your experience with the tribal court?
Yes, I very much enjoyed practicing law at the Penobscot Nation Tribal Court. I think that they are wonderfully efficient and also wonderfully informal, so that things can get done, obviously within the rules of law. But it has been it's been a very pleasurable experience to practice law in tribal court in the Penobscot Nation. I mainly did two types of work in tribal court. First was as the lawyer for child support enforcement, and second, later on, I was guardian ad litem in a lot of cases. Judge Maynard would appoint me as guardian ad litem in many cases. And so not only did I get to know the court system, but I got to know tribal members as I was guardian ad litem for children on Indian Island. And it was a wonderful experience.
Thank you for that. Thank you for your service. I thought the Chief Justice, former Chief Justice, might have had it right by going from the bench to academia, but good luck to you.
Thank you.
in this momentous transition in your life, and congratulations on your nomination.
Thank you so much.
Thank you, Representative Babbage. Thank you for your responses. Are there additional questions from committee members? I do have a few,
yes.
And it has to do with some of the answers that you provided on many forms that you had to fill out.
There are a lot of forms.
You gave a very thoughtful response, I thought, to the question how the system of justice in Maine can be improved. And you focused on what you perceive to be an imbalance in power in the civil arena, because some people are represented, some are not. Could you elaborate on that a bit and ways that you think we might be able to correct that imbalance?
Yes, and you'll note that I addressed that only after acknowledging that the imbalance of power in the criminal system is frequently discussed. So by talking about the civil system, I am not ignoring that imbalance that may occur in the criminal system. But so thank you just with that. Okay, so my experience in the civil system and its imbalances are that lawyers serve a really valuable purpose. And I can name you, I could tell you lawyer jokes, and I'm sure you all have some of your favorite lawyer jokes, but lawyers generally provide a really good service. I like lawyers. I've always liked lawyers. I like them as friends. I like them as advocates. And their purpose is to make sure people know the rules. Each of these systems have rules. And if you don't know the rules of the game that you're playing, you're pretty much not going to win. So that's what lawyers do. And in cases such as private family matter disputes, you don't always have, everybody doesn't always know the same rules because lawyers are not involved in for each side. So that has always been a concern of mine. I appreciate that you need to balance out the resources that are available. I'm not suggesting that everybody getting divorced should have court-appointed lawyers, but there needs to be some way that we can even out that balance for folks. I think I mentioned in my answer that some of those really high priority, high risk situations, losing your home, losing your child, that perhaps we should consider more the availability of legal services on a more frequent basis. It all boils down to resources, but that's been a concern of mine.
Thank you. And I noted that you did talk about those high profile cases where one has a lot to lose. Have you considered adopting something along the lines of a civil Gideon standard, that when the rights are that profound, that perhaps representation should be required?
Yeah, so I have not considered that, but I appreciate the thought. And in fact, we'll be teaching this on Wednesday, the idea of Miranda rights, the idea that having a lawyer is such a profound right that law enforcement folks need to, in certain situations, let the defendant or the person being interrogated know about those rights. So yes, I think that that's probably someplace where you should start, is what is the right that's being implicated and how profound is it? Thank you.
And in the event that you or your students come up with an answer, if you could
Absolutely.
report back to us.
Well, I'm always telling my students that, if you see a problem, become a legislator, right? Go make policy, solve it. I always tell them to do that. So I will continue to tell them to do that, and hopefully we'll send multiples of them here.
Thank you. I just have one more and I'll get right to you, Senator. And I wasn't going to let you off the hook on the criminal side. I started with the civil, but I did note.
You can let me off the hook.
Thank you. You mentioned that it's about time to seriously consider a public defender's office. What's led you to that viewpoint?
Well, you saw that my background was in California and then Alaska. And so California had a public defender system. Alaska had and has a public defender system. And then we moved to Maine, and it was like, there's no public defender system here. And so it took a while to sort of figure out how defendants were represented, if indigent defendants were represented. And as I learned more about the system, and in fact, when I started with Lafayette, Esperance, and Kaminsky, I would be appointed to represent defendants. I would be a court-appointed defender. I did I did some juvenile defendants, so I would represent juveniles. I saw that it was working. It was working. You would have folks like me, sincere, really trying hard to represent the person the best as I could, getting paid minimally from the state, but appeared to be working. So I think that as population expands, as needs expand, as lawyers are leaving the field, it may not be working as well as it had been previously. But I understand the limitations to a public defender's office, just like there are limitations to the private court-appointed lawyers. So you all will hear evidence, you all will hear the best evidence about what works best, and trust that you will provide our indigent defendants with the best legal representation available.
Thank you very much, Judge. Senator Carney.
Thank you. And I'm sorry I interrupted your line of questioning. I want to take you back to some questions actually that my co-chair asked you about civil matters and the importance of legal representation. And I was wondering if you could speak with us a little bit about what you as a member of the judiciary would do to address that imbalance absent resources that would allow more civil defendants who couldn't afford lawyers to be represented.
There are certain workarounds that might be available to judges. And I'm not going to be able to think of all of them right now, but one that I can think of right away would be where children are involved, appointing a guardian ad litem. So at least there's somebody there that can represent the best interests of the child. So that's one workaround that I can think of. The other is in divorces and parental rights matters, the court is able to order that one party pay the attorney's fees of another party. There's another workaround, if you will. So I think that being creative, you may be able to come up with some solutions.
Thank you.
Thank you, Senator Carney. Are there additional questions for the nominee from committee members? I am not seeing any, so thank you very much for your statement, for your thoughtful responses to our questions.
Thank you very much.
I will now turn to statements from the floor. Chair will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted the statement to the committee clerk prior to today's hearing. All such statements contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee upon her request before the committee votes, and the nominee will have an opportunity to respond to the written comment if she so chooses. Those who wish to speak during the proceedings should observe the following. Those who wish to speak on site in person should do so from the rostrum. Those who wish to speak via Zoom should have registered to testify online prior to the start of this hearing and will be called upon by the chair, at which time they will be promoted to panelist status in Zoom and can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence before presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. Those speaking should remain at the rostrum or available on Zoom in the event members of the committee have questions. After you are done speaking and there are no more questions from members of the committee, you may return to your seat or you will be returned to attendee status in Zoom as applies. I will first turn to members in the audience and ask those who wish to speak, if you could raise your hand. Judge Mitchell, you seem anxious to get up, so welcome.
Always anxious to speak for Judge Fairclough. Good afternoon, Senator Carney, Representative Harnett, distinguished members of the Judiciary Committee, and Judge Fairclough. It is so refreshing to have sat through her testimony, and I think you can see what those of us who've sat on the probate judge bench with her with numerous meetings have learned. She is a teacher at heart, whether it be the law or the human condition or how we can make things better. But I must admit, I learned even more things about this extraordinary woman. I'm not going to read everything that I've written for you. When you're writing a judicial opinion, you have findings of fact and conclusions of law. I suggest that we've found many facts already through her resume. We've found that she is eminently qualified. She is articulate. She is experienced. And in fact, I might call her a Renaissance woman with all the things that she brings to the table today for your consideration. So, and there's one other fact that you might not know, and I bring to you because I've had the pleasure of serving as a fellow probate judge with her. We all reach out to one another for advice, for experience. What would you do with? And Amy Fairclough, always the teacher, does her homework, refers to citations, refers to precedent, and she teaches us every single day. And she even taught a course that qualified for a continuing legal education credit for the other judges of probate. That's the quality of her teaching level. She very quickly rose to the top, if you will, of the leaders in our assembly. As we exchanged ideas, she never, ever felt embarrassed to ask a question. No question was too simple or unnecessary. She asked it. And boy, did she make everybody think about where we were, what the law meant, and what we should be doing about, what should be concerned about. Even made her secretary, and you know what that's like to be made secretary of any organization that's losing it. She took it on. She did not complain. Her intellectual curiosity is boundless. I really struggle to keep up with all the questions that she asked, but that is a trait that you would want from any judge. So the conclusion of law is that she represents all the best aspects of what we want and what we're accustomed to in Maine and the judges that we've selected. I read a few Bar Association journals about what is an ideal judge. She has these qualities. And they define judicial temperament, again, a quality that can't always write on paper, but however, it's the ability to apply the law to the facts, but also to know how that decision affects the person before you as you apply those laws to the fact. She has to listen to all sides, which she does, but then have the courage to make the decisions, which may not always be popular, but are best in the best interest of the citizens, and follow the law which the policymakers have issued. And she does have that courage. And what I also believe that she will do, and some of your questions implied that that too is an important goal, she will work with her colleagues to make the system better. She is not satisfied with the current situation. She makes it better. She didn't mention to you, one of the things that she does a lot in her probate court is she uses mediators, which helps people resolve problems on the courthouse bench, even without a benefit of law. So she is all of those things. And I, without hesitation, am so pleased to endorse this nomination to the bench, though I think Penobscot County is going to have some pretty big shoes to fill in that probate role for however long it lasts. So I appreciate your time. And again, she is an extraordinarily good choice. Thank you, governor's staff.
Thank you, Judge Mitchell, for taking the time to be with us today. It's
Thank you.
always nice to see you before the committee.
Thank you.
Are there questions from committee members for Judge Mitchell?
I keep forgetting about that.
I am not seeing
Thank
any.
you.
Thank you very much. Judge Crockett?
It's always a tough act to follow. Oh, sorry. Representative or Senator Carney, Representative Harnett, distinguished members of the committee. My name is Jared Crockett. I'm of Bethel. Let me clarify now, that's Bethel, Maine. And despite the Alaska connection, I spent 3 years there, but no connection. So here we go. Like so many other who work in these hollowed halls, I too enjoy history. And today we get a chance to be part of that because Judge Faircloth is only the second probate judge in 50 years to go to the district court. The last one was quickly elevated to the Superior Court after their service because a lot of the traits that work on the probate court, working with pro se litigants, understanding various issues, they apply. And so I fully expect Judge Faircloth to fall into that category. Usually when evaluating anybody, whether it's a combat leader in the military, an officer, or a business executive or a judge, there are two factors that are necessary: aptitude and attitude. Aptitude is the ability, obviously, to learn. It's imperative for a judge to have a strong legal foundation and a sound legal mind to even be considered. However, it is vital for the person to, well, vital for anybody considering the job, to realize that no lawyer is a master of every area in which that district court has jurisdiction. It's impossible. And if any lawyer were to tell you they were a master of every area, you probably wouldn't want them as a judge, because you have to have anybody who's talented has certain areas. But when they become a district court judge, they have to pick up those new areas. It's no surprise. And that's where the aptitude part comes in. Here, you have the unique opportunity where you have a nominee who's already been through that before. Because when you become a probate judge, you may have a particular area, but you may not be an expert in complex trust litigation. You may not be an expert in adult guardianships or family law. There's various complex property issues. So you've already had a nominee who's went through it. It was successful. So you've already got a proven track record. The other piece is you have a Judge Faircloth has come to the bench with over 30 years of legal experience prior to becoming a county judge. From the start, her aptitude to quickly digest cases and apply areas of law was evident to the attorneys as well as the various parties appearing in her court. And while her aptitude is clearly evident, it's also her attitude that truly sets her apart. That's the second part of the evaluation. The judicial temperament. To date, all accounts, she's excellent. She has a proven track record. And again, a big benefit to the district court there. Now, one of the greatest attributes of a probate judge, I feel, having been in the district, superior, and probate courts, and now having sat on the bench of the probate court, is the pro se litigant. So you talked about civil suits earlier. You have cases where you could have hundreds of thousands, sometimes even $1 million estate, and two pro se
individuals arguing points of law. Okay, not understanding exactly what they're arguing, and not necessarily the rules of evidence sort of get interesting, but you're trying to cipher it out. Probate courts have to do that routinely. They're unseen to the bar, but to be able to do that, that translates into a good district court judge. Because if you ever had a landlord case or an FED with a pro se litigant on the other side, you understand the complexity of that and how a district court judge has to maintain that demeanor, the respect, the decorum, so forth, but still make sure the procedure isn't ignored. Here, you have a nominee who has that background. But on a personal note, I first encountered Amy on a small case over a decade ago, which she was not happy with me on. But her wit and keen grasp of the issues took the day, and I've enjoyed working with her ever since. When she became a probate judge, she has definitely become a key person in our assembly. And it's hard because we each are working I'm sure people who served on that commission this summer understand these counties are working in silos. So the probate judge's ability to reach out to other counties is necessary. And right from the beginning, I think it's fair to say we've all benefited a great deal by our input and collaboration. And again, all indicators, it should be an excellent district court judge. So in conclusion, and I know brevity is next to godliness, so I will get this done quickly, is a rare occurrence when the Judiciary Committee has the opportunity to vote to confirm someone to the state courts for the first time, who has presided over hundreds of hearings in cases ranging from multi-million-dollar estates, termination of parental rights, to both adult and minor guardianships. Judge Faircroft's proven track record on the bench, coupled with her legal expertise, makes her an excellent choice for the district court. I humbly urge this committee to support her nomination, and thank you for your time and consideration.
Thank you, Judge Crockett. Nice to see you before the committee again. Nice to see you in person.
And I want to note that I did pay tribute as required. So if Soupy says anything.
Just in the event committee members have questions. Are there any questions for Judge Crockett from committee members? I am not seeing any. Thank you very much for your time and being with us this afternoon. Come ahead. Good afternoon. Welcome.
Good afternoon. Senator Carney, Representative Harnett, and members of the committee. My name is Wayne Doan, and I'm an attorney in Bangor and have been for about 33 years now. And I appreciate the opportunity to be here today to talk to all of you in support of the governor's nomination of Judge Faircloth to be a district court judge. I've had a district court practice now for just about all of my career, all of my 33 years. I also practice in probate court, and I'll talk about that in a second because that's one way that I've encountered Judge Faircloth. And I also practice in the tribal court as well. I do family law, but the primary focus of my practice is child protection, both as a parent's attorney and as a guardian ad litem. And it probably will come as no surprise to anyone that for those of us in the legal profession, judicial nominations are a really, really big deal. The word spreads like wildfire. Somebody sees it on a news feed, and then we all start talking about it because it really is such a significant event for us. And the child protection bar in particular is a very, very closely knit bar. And we spend a lot of time together. So we're huddled around our sort of virtual water cooler talking about these things. And by that, I mean that awkward moment when you're waiting for the Zoom hearing to start, waiting for the judge to get there. We're all kind of awkwardly looking at each other. Those are our opportunities to talk. But I'm not just speaking for myself today. I can tell you that I've had an opportunity to talk with a number of my colleagues about this nomination. And I can tell you, not once did I hear any discouraging words about this. And the comment that I heard most frequently, almost in these words most of the time, was, yeah, it should be great. Yeah, it should be great. And I certainly agree with that. So the question then becomes, what is it about her? Maybe you've heard a lot of it today already. But what is it about Judge Faircloth that makes her the right choice, that makes this a great choice? And I think it starts with her considerable experience as a practitioner, Her trial experience as one of the founding partners in one of the most respected firms in Bangor. And believe me, lawyers like to try cases in front of judges who have trial experience. In addition to that, and we've heard a little bit today about her experience as a guardian ad litem, and I've had that experience with her on a case. And one case in particular that I remember just a few years ago was a case in tribal court. And Judge Faircloth was the guardian ad litem for the two children in that case, a very, very difficult, complicated, messy, and difficult situation. Judge Faircloth was a very strong and very effective advocate for those children. I represented the mom in that case. And her work in that case, her tireless work in that case, was extremely helpful in bringing that case to the appropriate resolution. I think having a district court judge, I know there was a question about that earlier, but having a district court judge, I think, that has had the experience of advocating for children in court and being a guardian ad litem, I think that's very, very important. We've also heard about her work with Huston University. She's a respected professor there. One of the things that I will really miss is being able to go to Judge Faircloth's classes and talk to her class. She was kind enough to invite me several times over the past few years to talk to her class. And we just did it actually just a few weeks ago. And it was always so much fun to do that, to see her interact with her class, to see her teaching her class. And as Judge Mitchell mentioned, she is a teacher through and through. Her class clearly enjoyed being with her, as she clearly enjoyed teaching them. I was always impressed when I went there to talk to her classes at how incredibly prepared they were to talk to me. They all had their lists of questions ready to go, and Judge Faircloth was running the show and had her list of questions, so there were no gaps in the conversation. And I'm sure that they're going to miss her there, but Huston University's loss will certainly be the court's gain. But I think the aspect of Judge Faircloth's career that I'd like to focus on the most in the few minutes that I have with you today is her work as a probate court judge. And we've heard some things about that today, because I think maybe the best predictor of what kind of a district court judge she will be is to look at what kind of a probate court judge she has already been. And I've practiced in front of Judge Faircloth in many, many, many cases in probate court, including twice just last week. Although I did settle both of those cases, so no heavy lifting for her that day, but I've been in front of her many, many times. I watched her very skillfully and carefully guide the court through the challenges of COVID, and that really did wreak havoc with our courts, leading into the kind of brave new world of video hearings, which nobody likes, by the way. I've read a number, not that we can do anything, but her decisions are very thoughtful, carefully written, and well-reasoned. And I say that even when they don't say exactly what I was kind of hoping that they would say. I've seen Judge Faircloth very calmly, and she does not ruffle, very calmly handle a number of difficult emotional situations in court, and handle them all very, very well. And yes, on occasion, as hard as it is to believe, sometimes difficult attorneys. I mean, not me personally, but I have seen other lawyers, they happen to be on the same case as me, right, Don? Being difficult. Although, in all fairness, and I did get permission to tell this story, in all fairness, there was one time that I was testifying in Judge Faircloth's court. I was the guardian ad litem in the case. And I got into it with the lawyer who was asking me questions, more than I should have. And I knew in the moment that I was going to get in trouble, but I just couldn't stop. So then I got a look from Judge Faircloth that I think probably her sons have seen before. And let me just say that she addressed that problem, meaning my behavior, that problem very efficiently and very quickly. So she runs her courtroom with a very fair hand and a predictable hand. And the predictability is a big deal for those of us who practice. And she has a thorough understanding of the rules of evidence. And believe me, that is important to lawyers. And I think that comes from her vast experiences as a trial lawyer. I think that's where it comes from. It comes from seeing those issues come up in the cases that you're handling. And I think that's where it comes from, but it's incredibly helpful. But there was a question earlier about folks who don't have lawyers. And I want to talk about that for a little. I want to talk about what I've seen from her in terms of her interaction with folks who don't have lawyers. I've seen her interact with pro se litigants many, many times, and she is unfailingly kind, patient, and understanding in her interactions with them. And she never forgets, and this is clear, she never forgets that these are folks who are in a very difficult emotional situation. Maybe they've never been to court before. They're way out of their comfort zone. They don't know where to sit. They don't know where to stand. They don't know when to talk. And it's a really, really hard process for them. And I think the ability and the willingness of a judge to make these folks feel like they have every right to be in that courtroom, they have every right to be heard, and what they say is important. And I think that's an essential skill set for a judge, because we do see a lot of folks in district court who don't have attorneys. And I'm speaking especially of protection from abuse days, because that system is designed to be user-friendly, and we don't see a lot of lawyers in that process. And I've watched judges handle that, and that can clearly be a very, very challenging situation. They're all, the plaintiff and defendant, all of them in the same room. I've heard them start going at each other in the courtroom. So that ability to relate and to talk to folks like that is an incredibly important thing for a judge. And the other thing is that when people leave a courtroom and they feel like they've been treated with respect, and that the person sitting on the bench really cares about doing the right thing, and that's always true with Judge Faircloth, that can only increase trust and confidence in our court process, and we all benefit from that. It can also help people accept decisions that are not exactly what they were hoping to get. If you feel like the process has been fair, even if the decision isn't what you wanted, at least you feel like you've been heard. They can accept it, they can move on. Otherwise, they never accept it, and they never move on. And I think that's particularly true in the area that's my primary practice focus, and that's child protection. There's a lot of interaction in child protection cases between the judge and the parent, more than I think a lot of people realize if you don't do that work every day. Because literally, every time we go to court, the judge and the parent have a pretty extensive conversation about a variety of things. I saw it this morning. I was in Belfast this morning with Judge Walker, and he had an extensive conversation with my client this morning. When parents are waiving their right to have a hearing, or they're agreeing to a particular order in the case, there's a colloquy between the court and the parent about, have you been able to reach your attorney? Has your attorney answered all of your questions? They want to be sure that they know what they're doing, and that they're making an informed decision. And I think the ability of a judge to make these folks feel like they're talking to them as opposed to down to them is pretty significant. And Judge Faircloth certainly has that skill. Not only that, but kids in these child protection cases also occasionally talk to the judge, and she would be great at that. I've seen her talk to kids, and she would be wonderful at that. So that's about all I have for you. I'm going to miss practicing in front of her in the probate court, but I'm going to look forward, hopefully, to seeing her in the district court. And I would suggest to all of you that the governor simply could not have provided you with a more qualified or deserving nominee.
Thank you very much, Attorney Doan. We appreciate you sharing your professional experiences with the nominee. Just before you leave, are there any questions from committee members for Wayne Doan? I am not seeing any. Again, thank you very much for your time and insight. Are there other persons in the room today who wish to testify? Is it Dawn Pelletier?
Yes.
Okay, welcome to the Judiciary Committee.
Thank you. My name is Dawn Pelletier. I reside in Bangor, Maine. And so Senator Carney, Representative Harnett, members of the Judiciary Committee, I have had the privilege of being partner of Amy Faircloth for almost 25 years. I kind of feel like everything's been said, but not everybody has said it. So I'm going to go ahead with my prepared remarks nonetheless. And I'm going to start by saying that I recently went to Disney with my 10-year-old niece. Now, I know you didn't expect me to start like that, but it got me thinking about Amy's superpowers. The ones that will make you very proud to confirm her nomination, especially at this time with the problems caused by the pandemic. 3 of Amy's superpowers are linked together. Number 1, Amy has the ability to see the forest through the trees. Number 2, she is very efficient in analyzing that. And number 3, she's decisive. So when I struggled with complicated cases, I'd ask for Amy's help. And we'd sit down, she'd listen attentively, and I would give her the facts. In complicated cases, especially family cases, there are many facts. One can get lost in facts. And I would ask her opinion on how to solve these issues. She thoughtfully thought about what was not important, disregard those. She focused on the important facts, applied the law, and provided alternate solutions. This is very helpful to me. It's always great to be able to talk to somebody as gifted as she is. So when you've got what we hear, about 80% of cases that are in the district court involve people who are either unrepresented on one side or both sides being unrepresented. It's very daunting for a judge to try to make sense of all these facts and then apply them to the law. I also read in the Press Herald that there are there's a $6,000 backlog of divorce cases. The district court needs judges with Amy's superpowers. The 4th and 5th superpowers are also connected. Her humanity and her humility. This I'll just never forget about our relationship. When she had complicated cases, she'd come to me. And if not all the time, most of the time, she'd always begin by saying, and you know, Dawn, I really like my client. So it got to be a joke, you know. When she'd do it, I'd say, okay, let's get this over with. I know you really like your client. But over time, I realized that what she really meant is that she really cares for her client. And Amy cares about people. She understands that not everyone has had the gifts that she's had, the opportunities that she's had, the parents that she's had. She understands that many people that come before her are in pain. And she understands that because she's had her share of her own pain. And she certainly helped me, as well as other members of her staff, through their own personal pain. I think it was Maya Angelou who said, people won't remember what you say, but they will remember how they made you feel. Amy will make people feel respected and heard. And then there's her humility. As we all know, it's very easy to be humble when you have a lot to be humble about. But that's not Amy. She's had an exemplary legal career, working hard on behalf of her clients. And in her spare time, she raised her kids. She wrote a book with her sister. She learned and taught yoga. In her later chapter of her career, she's now a professor and a judge, an elected judge. You know, I have a lot of respect for all of you who put yourself out, right, to be examined. I just think that's remarkable. She's a proud mother, a loving sister, and a devoted daughter. But if you ask her, what's one of the hardest things that you ever had to do? She would say, she wouldn't even hesitate. She would say this, what she did today, a few minutes ago. She doesn't like talking about herself. She's uncomfortable talking about herself. That's what you want in a judge. Someone who doesn't take herself too seriously. And when the citizens of Maine appear before her, it's not going to be about her. She will give all her attention and her energy to the people in front of her. Finally, I want to talk about her courage. She's tough. She's very, very tough. I've heard her tirelessly advocate for her family and for her clients, while up against highly regarded lawyers who any lawyer on the other side would be intimidated. And she was, but that didn't stop her. She held her own. It takes courage to make decisions, have the sort of confidence and courage to make decisions about people. These decisions are going to affect their lives. It takes courage to take control of a courtroom and to hold people accountable. Amy is brave. She's tough. I first appeared before this committee 31 years ago when I was the nominee. And I'll be, not 31 years ago, when I was 31 years old, and I'll be 66 in a couple of years. Over those 35 years, it's hard to believe, right? Just, where did it go? I've spoken on behalf of many, many nominees. And this is likely the last time that I'm going to do it. So I do it, you know, cherishing the privilege that I've had to appear before this committee. But I'd like to take the opportunity to thank you folks for your service to the citizens of Maine and to our democracy, which we cannot take for granted. This committee has always confirmed the nominees that I've spoken for. So please don't ruin my record. And I heartily support Judge Fairclough's nomination for the district court.
Thank you very much.
Thank you very much for being here. You put a lot of pressure on us there at the end. Are there questions from committee members for Don Pelletier? I am not seeing any. Thank you again very much for your time and testimony. Is there anyone else in the committee room who wishes to offer a statement regarding the nominee? You're certain she does not want to? Okay. I would now ask anyone in the attendee space, if you wish to testify regarding this nominee, to please raise your electronic hand so that Committee Clerk Supi Panett can move you over. I do know that we had one person registered to testify, Susan Fonce. Susan, as soon as you're ready, please activate your video. It's nice to see you again. Please begin your testimony as soon as you're comfortable.
Members of the Judiciary Committee, thank you for having me again. My name is Susan Fonce, and I am president of the Maine Trial Lawyers Association. I'm here today testifying on their behalf. I am a resident of North Yarmouth, Maine. For this particular candidate, we did have a limited number of respondents, but for those who did respond, we received an overall positive nomination for this candidate. Our members described Judge Faircloth as performing admirably well in the probate court. And our members also noted that Judge Faircloth was beyond courteous to pro se litigants. In evaluating her nomination, our leadership noted almost 34 years of experience in civil litigation and child support enforcement. We believe this experience will serve her well in the district court. We also noted her efforts to keep dockets up to date in the probate court, despite the difficulties presented during the pandemic. This is a mindset that's necessary to keep justice accessible during these difficult times. Based on her high evaluations and her extensive legal experience, the Maine Trial Lawyers Association is proud to endorse Judge Amy Faircloth to the Maine District Court. Thank you.
Thank you very much for offering your testimony on behalf of the Maine Trial Lawyers Association. This afternoon, are there any questions from committee members for Susan Fonce? And I am not seeing any. Again, thank you very much for your time and testimony. I will do one more sweep of the attendee room and the room that we're in. Are there any persons who wish to be heard in any capacity regarding this nominee? Seeing none, I will move on to the next phase of our hearing. All public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee. We will vote on the nomination and notify the President of the Senate pursuant to Title III MRSA, Section 157, and the joint rules. Vote must be taken within 40 days of the date of the governor's written notice, and we are within that time frame. The hearing by the Joint Standing Committee on Judiciary for the Honorable Amy L. Faircloth of Bangor for appointment as a district court judge is closed. We will proceed to taking the vote. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, I ask whether any member present objects to proceeding to taking the vote immediately. If so, please raise your hand or your electronic hand. I am seeing no objection. The pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Amy L. Faircloth of Bangor for appointment as a district court judge be confirmed. In accordance with 3 MRSA, Chapter 6, Section 157, and the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the vote? Committee clerk, please call the roll.
Thank you, Mr. Chair. Representative Galgay Reckett.
Yes.
Representative Galgay Reckett votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
Yes. Yes.
I'm sorry. Representative Poirier votes yes. Senator Kime. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Sheehan. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby. I will recall the absentees. Senator Kime. Senator Kime is absent. Senator Sanborn. Senator Sanborn is absent. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent.
Thank you, Clerk Panett. 9 members of the committee having voted in the affirmative and 0 in the negative. It is the vote of the Joint Standing Committee on Judiciary that the nomination of the Honorable Amy L. Faircloth of Bangor for appointment as a district court judge be confirmed. Congratulations very much on this honor. Before we come to congratulate you in person, please accept a round of virtual and live applause for your accomplishment. It has been a joy to sit through these nominations today. Thank you for all committee members and everyone involved in this process, and congratulations. Committee members listening at home, we will be in recess until 3. Recess until 2:50.
one is what you asked for. Okay, I'll leave my
Peggy? Peggy, I
Yes.
had to step out to do the priorities with criminal justice.
Oh,
So
oh,
what's
good.
happening? Are we back in at 3?
Yeah, they were a little behind. They said maybe 10 up, but yeah, we still have to do priorities for Judish.
Yeah, that's why I wanted to get back here. So
Right, no,
I've sent
yeah.
my others in now, so I'm with you the rest of whatever we need.
Yay.
I said goodbye to criminal justice and public safety because I'm not serving next time in both committees. I cannot do it. So not retain my sanity. So never mind my body. So I'm gonna
You have
bow out
done
of
an
criminal
amazing
justice.
job, and it's been wonderful to have you as the bridge.
Yeah, but 6 years is enough. I think 8 is beyond the pale. I think.
Yeah.
So, particularly when I'll be 78 by the time the next session starts.
Woohoo, nice.
Yeah, really. I think the terms actually get done on December 31st, which is my birthday. So my theory is when I get done in my final term, I'll be 80. And that really is time to be gone. Not gone, but gone off.
Okay, I don't want to spoil things for you, but the term actually ends the first
In
Tuesday.
December. Yeah, I
So
thought
you're
it
gonna
was
have to run for
early.
another term.
Yeah, no. I'll just say goodbye early. That's
Okay.
Hey, Peggy? Is this is
Yeah.
that a bad
Representative
echo?
Moriarty, what's going on with your microphone? Maybe it's soupy with the room. Is that what you were asking about, Representative Angelos?
I was just wondering if the political parties were caucusing.
No.
Not
we
that
had
I know of. I think people were just taking a break before we get started.
And we had noticed the meeting for 3. I misspoke when I said 2:50. That was
Oh,
my
okay.
fault.
It wasn't an official notice. I just said we wouldn't be getting like to the public records exceptions before 3 o'clock at the earliest. But we have a couple of other things to do before that anyway. Yeah. Big things. How's Sheba?
He's good. Down East Magazine took a picture of her yesterday, but I don't know if it's going to make the article or not.
Well, it would be a mistake if she's not the star.
You know, I'll hear about it.
all right, all you
righty.
Jill souls, I'm just signing up for my 60th high school reunion.
That's funny. All right, should we begin our priority setting? And so we have our priorities and we've got some freedom of access reviews. And sadly, I have another meeting at 4:30 that I have to run off to. So I'm hoping we can get as much done as possible. And we're actually going to start with the priorities because that is something that is due to AFA pretty soon, supposedly by 5 o'clock tonight. So I think, did everybody receive the chart from Peggy? Looks like this.
Yep.
Okay. And I think that Peggy had asked at Tom's and my request for people to rank bills in tiers. So your high priority, important, and then lower priority, and to try to keep roughly a third in each category. And the reason for doing it this way is so that we can identify if there are some priorities that we are all focusing on and have ranked highly, then we can advance those as the committee priorities rather than just doing a straight numeric calculation. And so I want to take it kind of one page at a time and ask committee members. Let's start with, I'm just trying to think of the easiest way to do this. I'm going to read the bill numbers. And if you can raise your hands, your physical hands, when we get, if we get to a bill that is your number one priority, raise your physical hand, and I'll just make a note so that we can sort of see which ones, like number one meaning top tier, most important. And we'll see if there are, see which bills rise to the top just by going through our top priorities. Representative Evangelos?
Thank you, Madam Chair. If you're going to go in the order that these are in, I'm not going to speak to any of the others, but I do want, since I think it's the first one that's going to be mentioned, I've been working on this for 4 years. It's the post-conviction bill. We heard overwhelming testimony that we have innocent men and women in prison. Walter McKee was asked at the hearing for this, do we have any innocent people in prison? And he says, yeah, I represented a couple of them. So, and Mr. Cummins and others. And despite promises I've received from the higher ups at the Attorney General's office that this time limitation and due diligence standard wasn't going to be used anymore, they continue to use it currently right now to this day to frustrate justice. So for me, I mean, give everybody a chance to speak, but my highest are going to be the indigent legal fix and LD 54. I'll wait my turn now.
Okay, so we're going to start with LD 54. And so I'm just going to ask for just a straight count for committee members who feel that LD 54 is a tier 1 priority. So we've got 1, 2, 3, 4 of us. Okay. And Lois.
Was Jeff's hand up?
Yeah.
That's
Yes.
what he just talked about. Okay.
Lois, is 54 a top tier 1 priority? Okay, so it's for all 5 of us. Okay. 233, confidential juror info. And Jeff, your hand is still up. For Steve, that's a top priority. Okay. 277, prosecutorial districts down east.
That was
Three, pardon me, Lois?
That was a second tier for me, but
Okay, yeah,
still high.
we're just doing tier 1 at this point.
Okay.
So 344 ERA, top priority.
Not gonna happen.
Yeah, I would have liked it to be a top priority, but I
Mhm.
don't think it's going to happen either. So I don't think it's worth asking it to be funded.
So you had 3.
Okay, so 3 on that one.
Mhm.
461, reduction of a main care lien. Heather, we're just raising our hands for top tier priorities. I'm not seeing any for that one.
I haven't done this work, so I'll just listen, but I'm really far behind in my work, unfortunately. And I just got my HCIFS ones done an hour ago, so I didn't get to this. So I'll just listen in. Thanks.
Thank you. We appreciate your thoughtfulness. Okay, 478, compensate unjustly incarcerated. Jeffy, yours, that's a top one for you and for Tom. So 2 for that. Presumption of entitlement to counsel. This is 480 for, I think this is for persons subject to guardianship. That's a top tier for me. Okay, so 3 top tiers there. An act to combat sexual exploitation of minors in Maine, 545.
I had that as high, but I don't know what the fiscal note is. Sometimes I was looking for low hanging fruit.
Yeah, I don't think we know that yet.
Okay.
Do you want me to put you down as a 1 on that one?
Sure.
Peggy?
I was just going to say it's increasing class of crime, so it's potential future biennium cost increase. So there wasn't an appropriation.
Okay. Just Tom's was the only one I got. Okay, thanks. 585, this is the negotiated bill, collaboration, gaming, and tax. So that looks like there's 6 of us on that one.
Is Jeff using his electronic hand? Is that-
Yeah, are you using your electronic hand, Jeff, rather than your real? Okay.
That was 6. I'm
Yep.
sorry.
Senator Carney, is it easier
Yes.
if I raise my hand?
Mhm.
Okay, sorry about
Yeah.
that.
Okay, 679, the statewide electronic warrant system. Is that top tier for anybody? Just me? Okay. 844, examine and amend conditions of release and probation. Representative Morales. Okay, so 5 there. Okay. 853, increasing fees paid to sheriffs for civil process. Okay. Flipping over to page 2. 903, Uniform Foreign Money Judgment Recognition Act. All right, we got one loyal sponsor. You get a gold star in addition to a check mark in that box. 906, Passamaquoddy drinking water. Okay, 6 there. Restricting weapons pursuant to harassment. This was the Representative Babbage was the only one who voted in favor of that.
Really?
Yeah, it was because I asked the committee to ought not to
Oh,
pass
so
it.
that's basically killed. So I don't,
Mhm.
all right.
Yeah.
Forget that I rated it highly.
1273, Conviction Integrity Unit. 2 top priorities on that one. 1303. This is a resolve that directs the reviser to compile a list of mandatory minimum. Not seeing any on that one. 1310, criminal records. Okay, 4 on that one. 1326, funding for Maine legal services. This is Barbara Cardone's adding 8 million the first year and 14 million thereafter to the baseline. It's distinct from the initiative that we as a committee put in response to our budget work. And so 1326 is a #1 priority.
Tier 1.
Tier 1 priority 3. Okay.
Just ask on that one again. The vote was 536. Work session. Who's that? The final vote was?
No. Peggy might, no, I probably, do you know what actually, Steve, you can look it up on your computer under divided reports.
They don't show until they're reported out.
Oh, 1326.
1529.
No, 1326.
1326.
That actually was reported out and it's on the table. So are you looking for the vote? I'm sorry, I couldn't hear.
That's been sitting there since last year, right?
Yeah.
Yeah.
Sorry.
Yeah, and Steve, you might be able to have your mic on too, but yeah, so
That's still,
so this is, how many people wish this to be their top priority? No, 1326. Okay, so we've got 1, 2, 3, 4. Now 1529, right to privacy. Steve, okay. 1626, this is the omnibus tribal sovereignty. Okay, 5. 1686, geographically limited public defender office. Now, this is a little different than what we put in our report back to the budget, modified that a little bit and made it the whole prosecutorial district, which is Kennebec and Somerset counties. And so while this is a priority for me, I'm going to rank the one that our most recent report back as a top priority rather than this one. But are there committee members who wish to have this as their top priority?
I'm confused, Ann. You're going to rank Kennebec and Somerset combined as number one?
Yeah, so the budget initiative we have is at the very bottom of the chart. It's the MCI Kennebec and Somerset County Public Defender.
So that I can drop this one and go to that other one.
Okay. But would anybody like to make this one a top priority? Are we okay with the other one? Okay. An act to improve child and family court process 1831. This is Senator Baldacci adding magistrates. 1856, eliminating conflict of interest with respect to payment of fees to bail commissioners. This puts the responsibility in the judicial branch rather than on the person subject to bail. Okay, so we've got 3 for that, 4 for that. All right, next, third page, 1899. This is safe entry and access for people seeking health care. Representative McCright. This is top priority, if this is one of your top priorities. Okay, so 6 on that one. Technical corrections to the main juvenile code. Tom, okay.
It's cheap.
It is cheap, but I'm almost hoping they could do it even without an appropriation. 1907, this is review of state lands and waterways that have sacred, traditional, or other significance.
That's nothing.
Lois, okay. Okay, 1918, an act to provide funding for guardians ad litem. This would allow families with limited resources to have guardians ad litem appointed in child custody and other cases. So 2 for that one. 3, wait, who was, okay, let's revote that one. 1918, 3. All right, thank you. 1926, a resolve regarding legislative review of the fee schedule, administrative procedures for payment of something that's cut off on my.
Actually, you can take that off. That is the MCILS rules. There is no cost. We didn't have a fiscal note until today, and there is no cost. So strike that right off.
Perfect. One down. 1943, an act to expand address confidentiality program for victims of certain human, and I'm not remembering. Trafficking. Top priority. 1, 2 top priorities. Okay, 1945 biometric identifiers, and we don't know yet whether that, we haven't reported out, so we don't really know what the fiscal note will be yet.
I think it's just going to be study costs.
Okay. And so that goes to a different group than AFA, that goes to Ledge Council, is that right? Okay.
Right.
So should we be ranking those, Peggy, or?
I think when I put it on the list, I wasn't sure if they were going to put any other costs on it, but they didn't. I remember correctly.
Okay. Okay. So we don't need to rate that one then. 1950, an act to implement recommendations of the commission to create a plan to bring the probate judges into the judicial branch. 1, 2, 3, 4. Okay. 2023, implementing recommendations of the Secretary of State regarding notarial acts, and that has minor costs. Peggy, do we know what's going to happen with that by way of a fiscal note?
My understanding is the Secretary of State said the cost would be absorbed, so it really shouldn't go to the table.
Great.
Okay, so we won't rank it.
I don't
or
think you need to rank it.
Okay.
Yeah, I'll take it off.
Okay, great. All right, and now we're getting to our budget initiatives. The first is the Rural Public Defender Unit. And for if this is a top priority for you, please raise your hand. Okay, that's
So just so you know, I've grouped them on this sheet. All of the unanimous ones are together in one. I tried to put them all in one box, but I flipped over to the next page. And the ones that are divided are in their own little lines. So if you want to take votes on them separately, you can, obviously, your priorities. I didn't know if you wanted to just say, here's our MCILS #1 priority, which is these 5 things. Or if you wanted to do them separately. However you wanted.
Everything on MCILS is high.
Okay. So do we keep them together, consolidate it together as a top priority?
They were all unanimous, right?
Yep. So are people comfortable presenting them as a package? Yes. Okay, good. All right, great.
Does that make them 6 or?
Oh, yes, so 6 in favor of them being a top priority. And then the next one was a divided report. It's the Kennebec and Somerset County Public Defender Office. This replaces the initiative from last time. If you're in favor of that as a top priority.
2, 3, 4.
So I'm seeing 4,
5.
5. Lois, is that a priority for you or no?
Yeah, that's okay.
Okay, so 6 for that one. And then the Civil Legal Services Fund, $4 million a year in the baseline. That's a priority for you. Please raise your hand. Okay, and that's got 6. Okay. So we've got is there any initiative that we went through that didn't get any votes that people feel strongly about, regardless of it not being a #1 priority for anyone or a top tier priority?
I'm sorry, were you saying ones with no votes?
Yep, something that nobody voted. Jeff?
Nobody at all?
Yeah.
Oh, it wasn't that it just didn't make the first list, it just didn't get a vote at all.
Yeah, this is just for if there's something that we didn't assign any top priority to.
Okay, yeah. Well, I mean, there were some close calls, weren't there? But I was told I only could approximately vote for a third of them. So,
Yeah.
But yeah, I mean, combating sexual exploitation of minors, LD 844, that's highly important, and I didn't vote for that. Everyone.
Okay.
That got 5 votes though.
So that got 844 got 5 votes.
Okay, I thought you. I
Pardon me?
get nothing. I'm all set.
Okay. Did you? If you did not vote for that and you want to add it as a 6th vote, we can.
Yes, I will vote yes. I just I started cutting down my yes votes.
Okay.
I thought I was supposed to save my ammo, but obviously I wasn't. So
I did as well, Jeff.
it's all right. It's this is the only way you can do this the way you're doing it. So let's proceed. I had a meeting we'll have 4 too. So fire away.
All right. And so Peggy, what we've done is we've ranked most of these according to top priority And I feel that we have a pretty good sense that we're going to have yeah, let me just
8 of them, I think.
Just counting all sixes.
Yeah, if there's 8 of them, if you count all the MCLS ones as one together. I mean, of the ones that are clumped together. I
Good.
think there's 8.
And Peggy, do we need to rank every single one of them in order, or can we just report back a group of 12 that are our top priorities?
I think committees are doing it various different ways. And if you're comfortable reporting back, here are, you can give them the whole list if you want, but you can say, here are our top 12. And I think that's perfectly fine.
So I think maybe what we can do, I have a suggestion with the committee's permission, is that we could move on to the public records exception reviews. And I can take a little time to rank these according to how many votes each one gathered. And then between at the appropriate break between reviews, I can read down the ranked list, and we can all decide our comfort level with that list. Does that sound okay to everyone? Yep.
As a shortcut, I counted, I think 13, which were 4 or above.
Oh, great.
So-
Okay. All right, so I'll just make it, thank you. I'll make a list of the 4 or above and then and bring it back to you after we do the next right to know.
Does anybody, I'm sorry, does anybody have the count on 1273?
I have
Yes.
2.
2.
I'm lobbying here.
Okay, well, let me do the list and then we can see, because we can add a couple more on if we feel the need. So let's do it. Okay, so I'm gonna deactivate my camera and keep my ears open for the public records review, exception review, and turn it over to Tom.
Thank you. We have, in a manner of speaking, 3 public records exceptions, except one of them has 3 exceptions within it. And I'm going to go from the order that we have on the agenda, which to me is saving the hardest for the last. So I would turn to 1748. And I've gone through the materials, have answered the questions as I see them, but we will need a presentation by the Committee of Jurisdiction. Is that right, Peggy?
Yes.
Okay.
And I believe that Senator Ned Claxton is here to present for the Health and Human Services Committee, both this one, 1748, and LD 2007. And I'm not sure. I know Anna Broom, one of the analysts, is here. Oh, and Sam Senna, they're both here. But I believe Ned Claxton is ready to present. Senator Claxton is. I will move him over if he hasn't already done that.
Welcome back to the Judiciary Committee, Senator Claxton. Nice to see you again.
Thank you, Mr. Chair. Do you want me to go ahead and start with 1748 then?
Absolutely, thank you.
I'm Senator Ned Claxton, representing Senate District 20 and Chair of HHS. We considered several bills that you'll be hearing about today and for which we need a waiver of for protection, for confidentiality. The first is LD 1748, which was the outcome of 2 bills in the 129th that generated a report about how to help people get out of poverty. One of the things we learned from the initial report was that there wasn't enough good data collected in a way that was usable. So we revisited that and are now asking for permission to continue to collect data that's already collected, but being aggregated in a different manner to produce both substantive material in which to address TANF, the program that is 6 years long and 5 years long. It gets helps people get out of poverty. So this is an effort to improve the data, and it's not collection of new data, it's aggregation in a new way. And it also interestingly includes qualitative data, not just numeric quantitative data, because it was felt that the stories and the specific instances of interaction with the department were important to capture. So the ask is that we be able to keep that confidential. It's already being kept confidential, but in pieces spread across multiple different reports. So I can run down the statutory criteria if that would be helpful, but you sound like you've already done that.
Peggy, is there any problem with me doing that in the interest of efficiency? And Senator Claxton, please correct me if I'm wrong. We're just sort of running out of time here, and
will do.
Thank you. So going to our matrix, beginning with paragraph A, whether the record protected needs to be collected. The Committee of Jurisdiction determined that the data needed to be collected because it measured things both quantitatively and qualitatively. The value to the agency or official or to the public in maintaining the record is that it will allow for the creation of a comprehensive report that can help determine the effectiveness of TANF. Whether federal law requires the record to be confidential, on page 2 of the Committee of Jurisdiction's submission, it lists both federal statute and state statutes, but the question we have is focused on federal law, and the federal law does restrict the disclosure of personally identifying information for those persons on TANF. Turning then to the exceptions to see if it meets one of the more of the following paragraphs. I believe that it meets paragraph D. Paragraph D states whether the proposed exception protects an individual's privacy interest, and if so, whether that interest substantially outweighs the public interest in disclosure. The Committee of Jurisdiction determined, as did I, that there is no public interest in this personally identifying information, and that in fact there is a strong privacy interest on those persons who submitted that. Paragraphs E, F, and G are not applicable here. And then we go to the balancing or other criteria, and that's paragraph I. Any other criteria that assist the review committee in determining the value of the proposed exception as compared to the public's interest in the record protected by the proposed exception. The statute as crafted will allow the publication of a report that will be accessible to all members of the public. It will simply delete the personally identifying confidential information. And I believe that that is as narrowly tailored as possible in this circumstance. Did that align with your thoughts, Senator Claxton?
Very much. Thank you for that succinct summary.
So Peggy, we need to call the roll on this.
Yes, I think you do.
I should, because I did condense this process a bit in the interest of time. I did not ask if there were any questions from committee members for the senator from the Committee of Jurisdiction or from yours truly with the rapid analysis. And seeing none, Supi, could you please call the roll?
Is there a motion?
I need a motion to approve the public records exception. Do I have somebody who's willing to make that motion?
So move.
Motion by Representative Moriarty, seconded by Senator Carney.
Second.
So we have a motion from Representative Moriarty, seconded by Senator Carney.
Representative Galgay Reckett. Representative Newell.
Yes. Sorry.
Wait, that was Lois.
I'll go back and repeat. Representative Galgay Reckett.
Yes.
Representative Galgay Reckett votes yes. Representative Newell. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier. Senator Kine. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative
Yes.
Babbage. Representative Babbage votes yes. Representative Thorne. Representative Sheehan. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby. I'll repeat the absentees. Representative Newell. Representative Newell is absent. Representative Poirier. Representative Poirier is absent. Senator Kine. Senator Kine is absent. Representative Thorne. Representative Thorne is absent. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Do you want me to say the vote?
Yes, please.
Thank you, Mr. Chair. 7 members voting in the affirmative, 0 members in the negative, and 7 members are absent. That is the vote of the committee.
Thank you, and thank you, Senator Claxton, for bringing this forward to our attention. And again, having sort of perhaps unintentionally raining on your parade, did you have any questions about the process that we used this afternoon?
Not at all, and feel free to rain as much as you want in the interest of efficiency.
Thank you. We will now turn to why don't we hold off on going to 2007 and go back to our
Do we have somebody waiting?
Senator Claxton.
Oh, let's keep going.
Okay.
Sorry.
We will now turn to the public records exception contained in LD 2007, which is an act to create, and I'm just going to have to call it ALS, an incidents registry. Senator Claxton.
Thank you, Mr. Chair. This is a governor's bill, actually, at the request of a woman who's been working on it for a couple of years to try and help the state gather some data on ALS. There is a tremendous amount about the disease that is not known. So the initial intent would be to begin to capture the data for the state of Maine, but then also work for ways to collaborate with regional and national databases and at the same time protect confidentiality. The requirement would be that diagnosing providers or treating providers would flag this diagnosis as is done for 30 other conditions, and let the state collect the names and specific state of diagnosis, birthday, things like that, specific to each patient. Because it is such sensitive data and such a sensitive diagnosis, that would have to be confidential. And we would like to have it excluded from the public record. It would be one of those that, having once been established, a given patient could opt in when given the opportunity to participate in studies on ALS. But for the time being, it's purely a matter of collecting data about the condition and adding it to one of the state's many other registries with existing registry rules.
Thank you. Any questions for Senator Claxton before I run through our matrix? I am not seeing any, so I will begin again with paragraph A, whether the record protected needs to be collected, and we look to the conclusion of the Committee of Jurisdiction. In this instance, the Committee on Health and Human Services concluded that it needs to be collected if the state is to establish a registry of ALS cases in the state of Maine. Then B, the value to the agency or official or to the public in maintaining the record. Again, the conclusion of the Committee of Jurisdiction is that this will allow for Maine to identify trends within the state of Maine and also the demographics of people who have been inflicted with this illness, and also to share those trends and demographics with regional partners from other states. Whether federal law requires the record to be confidential, the federal HIPAA rules come into play because this is personally identifiable medical information that should not be disclosed under HIPAA. And as Senator Claxton pointed out, we also have almost 24 of these types of registries regarding other diseases and illnesses that are confidential under state law. This exception would be consistent with those. Turning to paragraphs D through I, my focus is on paragraph D, whether the proposed exception protects an individual's privacy interest, and if so, whether that interest substantially outweighs the public interest in disclosure. Again, this is personally identifiable medical information being collected to help the state analyze the data, and there is no public interest in the disclosure of that personal information, although there is great public interest in creating this registry to do this data analysis. Paragraphs E and F do not apply. Paragraph G asks whether public disclosure jeopardizes the safety of a member of the public or the public in general, and if so, whether that safety interest substantially outweighs the public interest. And again, this protects only personally identifiable information, allows the creation of a registry, and that registry, as I understand it, Senator Claxton, that will be a public document, simply not the personally identifiable information that the registry in its aggregate format will be available.
Yes.
And again, in terms of is the proposed exception as narrowly tailored as possible, this is modeled on other areas and particular diseases and illnesses and afflictions that we have measured throughout the state. And again, it is simply allowing for the publication of an aggregate report without the personally identifying information. And if there are no questions, I would entertain a motion to approve the public records exception regarding LD 2007.
So move.
Motion made by Representative Moriarty, seconded by Representative Evangelos. I thought I saw a hand fly up there. Thank you. Is there any discussion? Seeing none. Supi, if you could call the roll.
I would be more than happy to, Mr. Chair. Representative Galgay-Reckett. Representative Newell.
Yes, sorry. Neil, what?
We're going to go back. Representative Galgay-Reckett.
Yes.
Thank you. Representative Galgay-Reckett votes yes. Representative Newell. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier. Senator Keim. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne. Representative Sheehan. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby. I'll recall the absentees. Representative Newell. Representative Newell is absent. Representative Poirier. Representative Poirier is absent. Senator Keim. Senator Keim is absent. Representative Thorne. Representative Thorne is absent. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Mr. Chair, I have 7 members voting in the affirmative, 0 in the negative, and 7 members are absent. That is the vote of the committee.
Thank you. And that will close our work on LD 2007. And at this point, I will turn it back to Senator Carney to return to our prioritization.
Thank you for your consideration.
Oh, I'm sorry. You have nothing else you're presenting to us, right, Senator?
Not at all. I just want to thank you for your time and consideration.
Thank you very much. I apologize for not saying formally goodbye. Have a good afternoon.
You too.
Okay, everybody. So I'll do 2 things. One is to let you know the 6s, the 5s, and the 4s. And then I kind of came up with a suggested order, and I'd like to read it in the order and have people just see how that feels to them. So the 6s were 844, amending the conditions of release and probation with 205,000 roughly fiscal note. 585, the tribal collaboration, taxation, and gaming with an unknown fiscal note. 906, the Passamaquoddy drinking water, also unknown fiscal note. 1899, safe access to healthcare facilities, and that is noted to have a minor cost increase. MCILS budget initiatives, the big grouping, 6.5 million. MCILS.
I'm sorry, what was that? I apologize.
It doesn't have a
Oh,
number.
okay.
And then the MCILS budget initiative regarding the Kennebec and Somerset County Public Defenders, and that's 1.67 million a year. And then the last one in that top of the top priorities is the civil legal services at 4 million a year. The next grouping is LD 54, post-conviction review at 1.7 million. And 1626, the omnibus bill with changes to the main implementing act. And again, we don't know what the dollar amount on that is going to be. And Peggy, if I'm wrong on any of these dollar amounts, let me know. Thank you. And so that's it for tier 5. And then tier 4 is 1310. That's the criminal records sealing for certain minor offenses. 1326, civil legal services at 8.3 million the first year and 14 million thereafter. And then 1856, the judicial branch paying bail commissioners, and that's estimated to be 1.2 million a year. And then the last one in that tier 4 is 1950, and that's the probate commission, merging the probate courts into the judicial branch. So those are all of the ones that were those were our top 13 when we were looking at just our number 1 priority grouping. Did anybody have anything they wanted to add into the mix? Jeff, go ahead.
I want to speak about 2 things. First of all, I think we should vote for LD 344. The Appropriations Committee can count the math of the roll calls when they come in. I'm not going to go here to the 9th inning and then not vote for this. Let's send a vote down if we can, unanimous, and let's see what happens with the roll calls. And then the Appropriations Committee will take the appropriate action if we don't make it. This is too important for me not to vote yes on. I mean, I already did, but I just want to encourage my colleagues on this one. It's a big deal.
Okay, so by a show of hands, committee members, if you agree with Representative Evangelos that we should, even if we are concerned that it's not going to get the 2/3, that we should still include it as a priority. And if you're okay with that, please raise your hand. Okay, so we've got 1, 2, 3, 4.
I don't think Lois is responding.
Yeah, What number are we talking
You're
about?
talking about
The
ERA.
Oh, okay. All right.
Yeah,
That's
I
what
mean,
I
I
thought.
guess I just don't understand what purpose that serves. But
Well,
I
for
mean,
me,
it's wasted words in our memo is sort of what I think, because it won't actually be on the table.
well, I mean, it's not wasted effort when you consider what's at stake and all the work people like Lois have done on it. I want to honor that. I want to honor what this is all about. It's hugely important. And I just don't want people looking and say, well, they didn't even vote for that. You know, I just think it's only a few words on a piece of paper, but the broader picture is hugely important by implication. We don't know what the roll call is going to do. I know it's a long shot, but I don't want to send a signal that we gave up either.
Okay.
Everybody has
Yeah.
to vote for conscience.
No,
So
that's fine. I'm happy to be counted in favor of it. I mean, you guys know how strongly I feel about the ERA. I just think our exercise today is to prioritize table bills, and this is not a table bill. And there's no indication it will become one this year. So that's the only issue.
I'm going to add it in because it seemed like we want to honor all the hard work that Lois has put into it. And I'll add it into the mix when I read down the order. And I appreciate you raising that, Representative Evangelos.
And if I might,
Yep.
Sounds like I'm creating more words, but we could also state that in the report that if this gets to the table, this is an important thing for this committee.
Mhm.
If it doesn't get there.
Okay. And Representative Evangelos, was there anything else you wanted to add back into the mix? And I'm going to ask everybody this, if there's things.
Thank you. The history around LD 54 with the unreasonable fiscal note, which I've been fighting now ever since it was placed on it. I just want to give you a little of the history. High-level members of MACDIL joined me in writing Attorney General Fry and challenging the $1.7 million. This is an unjustified fiscal note. They have the largest law firm in the state on the 6th floor of the state office building. 97% of the people in the prisons took a plea, they pled guilty. We're talking about an extremely small number of people, and 1.7 million is unreasonable. They have the staff to take care of these few appeals. But my backup plan, if I can't get that through, would be 1273. These things are sweeping the country. It's called the Conviction Integrity Units. And I just am very frustrated at some of these numbers that get assigned to these bills, and then legislators have no recourse other than thank you for letting me speak about it today. But I mean, I've been talking to the members of the Appropriations Committee. Representative Cardone and Senator Bailey witnessed the testimony that was taken on the bill 3 and 4 years ago, and now all of us this year. So that's just a pitch. I'm not being selfish. It's just that the two bills are related. One is post-conviction reckoning and correction, and the other is these units within the Attorney General's office and prosecution offices around the country can unilaterally take up these cases when they know an injustice has occurred. That's all.
So are you urging that? So, okay, let's just take that into account, and we'll come back to it in just a minute. Committee members, are there other bills that people wish to add back into the mix where they don't feel like the prioritization really reflected how you personally thought the bill should be ranked? I had one that I was concerned about, and that is 1904, the technical changes to the juvenile code. It's just a $10,000 fiscal note, but it represents that body of work was a lot of hard and good work that was done by a diverse group of people. And I feel like it's important to include that back in, just to keep that make sure that all of that work comes to fruition in an implementable way.
And that was 1904?
Yep, and that was just basically indicating that information can be transmitted electronically rather than being delivered, or whatever the word used was, I think. Do you remember, Peggy, what the verbiage was?
Right, I think it's just transmitting the order. It's to seal a juvenile record. And it was actually a change that the SBI and the court both asked for. It just takes a little bit of one-time money to code the system to let it happen automatically rather than sending a paper copy of the order.
So how do people feel about adding that back into the mix here? If you're good,
Yep,
raise your hand.
I think I was the one vote, so I am.
Okay,
It's
Yeah,
only,
I'm
it's
fine.
under
too.
11,000.
okay, all right. All right, great. So now I am going to read down a kind of suggested order.
Madam
And
Chair, can I ask?
yes,
I'm sorry. I just got back from getting some antibiotics. Are we using a master list or just our list of bills? I have my own. What sheet are we working from, or are we working from a sheet?
we're working from this document that Peggy emailed to us
Oh.
on Friday.
Thank you. Thank you very much. That's
Yeah.
easier. Yeah,
Okay,
thank you.
yep.
He was not here. when we-
And we had gone through and as a committee we had asked ahead of time for people to prioritize their top tier. And we went through and for each bill counted the number of legislators for whom a particular bill was a top tier. And I'm just about to read through a proposed ranking. So Jeff, are you still able to hear us? I think that it's important for all of us to be on in earshot for this. Okay.
Senator Carney,
Yep.
I have to apologize. I have a 4 o'clock meeting with the governor's office, so I'm going to have to drop off.
Okay, thank you. Bye-bye. All right, so here's a suggested order. The suggestion is the large MCILS budget initiative package first, and then the MCILS Kennebec and Somerset County Public Defender second. The $4 million added to the baseline for civil legal services third. And then the Passamaquoddy drinking water fourth. The tribal collaboration taxation gaming bill fifth. Amending conditions of release and probation sixth. Safe, oh, okay.
Can you give numbers?
Yeah, I'm sorry. Okay, I'm going to go back and just give numbers after item 3 because the first 3 didn't have numbers.
Right.
So number 4 is 906, Passamaquoddy drinking water. Number 5 is 585, the collaboration gaming and taxation. 6 is 844, amending conditions of release and probation. 7 is 1899, safe access to healthcare facilities. 7.1 would be the ERA, and that's 344. 8 would be post-conviction review, 54. 8.1 would be 1904, the juvenile code. 9 would be 1626, the omnibus bill that changes the main implementing act. 10 would be 1310, the criminal records sealing. 11 would be 1856, the judicial branch paying bail commissioners. 12 would be 1950, the probate commission recommendations. And then 13 would be the second civil legal services addition to baseline of 8.3 million the first year and 14 million the second year.
Does that have an LD? Okay,
Yeah, it's LD 1326. Sorry.
Thank you.
So how does that feel for people? I have no pride of authorship, so critique away.
So what happened to the Jeff's bills?
Oh, so that's
Are they
right.
going-
Thank you. Thank you. So Jeff, 13, what was the commission?
1273.
1273. Conviction Integrity Unit.
Yeah, I was just lobbying to, it's still about getting innocent people out of prison.
Mhm.
I know it's just a few people, but if it was something, and I don't have a family member who's suffering from it, but I do know people in the prison that are, and you know, it's the biggest disaster that's ever happened to the family's life. And nothing worse, hardly. So I just, you know, those two bills are kind of linked together at the hip.
Okay.
May I ask a
Yes.
question? Jeff, can I ask you a question, please?
Certainly, of course.
Did the second bill has a much smaller fiscal note, the Conviction Integrity Unit 1273, but it ranks much lower than 54. Can you see 1273 taking the place of LD 54? I mean, because you keep calling them joined, and I don't.
Well, they're joined in principle in reference to the objective of the first bill 54. I don't want to leave it to only the prosecutors to decide when they're going to take up one of these. Certainly LD 54, you know, is a defense motion. And but the end game is linked in that we're trying to get justice right. So it's I wouldn't support bypassing 54 for this one. Just trying to get a plan together to get some justice for these people.
So the two trains are going to the same place, but they have different drivers.
They had a lot different drivers.
Right.
Yeah, and I think 54 where it changes the time frame in which one can seek review is, I think that's a particular glaring injustice in our laws, and so I would not want 54 to go away either.
Thank you.
I get it.
So Jeff and committee members, how do we feel about adding 1273, the Conviction Integrity Unit, onto the list?
This one does have the support of the Attorney General's office, so
Yeah.
that would help.
And then, so that would be 14, and then we would make the post-conviction review 15.
No, that's already on there, Lord.
Oh, it's already on.
Conviction's
Okay.
much higher.
Yeah,
Oh, good.
1273 would be the next one on the list, would be at the bottom of what we've already read.
All right, got it, check. Thank you.
Okay, and then was there another one that Jeff or others wanted to add back into the consideration?
So, Ann, can I just ask, are these in descending order of importance, or are they just all in the one big balloon?
Yeah, they would be in descending order of importance. So the most important one would be the two MCILS budget initiatives and the Civil Legal Services budget initiative.
The only thing I would do is argue for placement of 1310, slightly higher. This is the bill in which Class E crimes between ages 18 to 27 are
Mhm.
sealed. The idea being that Class E conviction shouldn't be a life sentence. I guess I would bump that up substantially. I hate to make judgments. If there's a question as to whether the ERA even belongs on the list, and it might go just before that.
So it would come right after the amending the conditions of release and probation. So committee members,
Yeah,
how do
The
people feel
healthcare
about that?
facilities was after.
Would it be coming right after 1899? Did I write my numbers down wrong?
Yeah, we could put it after
Yeah.
1899.
Yeah, that's what I had too.
Okay, okay.
And what number was it, Steve?
1310.
Okay,
Oh, I see. Okay.
all right. So would committee members like me to read through the list one more time so that it's clear? And I know Peggy would like that. And Peggy, please interrupt as we go through and ask any questions.
Okay,
So
thank
I'll
you.
just pause a little bit after each one. Okay, so the first one would be the grouping of MCILS budget initiatives, which doesn't have a bill number. The second would be the budget initiative for MCILS, again, without a bill number, for Kennebec and Somerset County Public Defender. The third would be the budget initiative regarding civil legal services, adding 4 million a year to the baseline. Fourth would be 906, Passamaquoddy drinking water. Fifth would be 585, tribal collaboration taxation gaming. 6 would be 844, amending the conditions of release and probation.
644?
844.
844.
6 would be 844, amending the conditions of release and probation. 7 would be 1899, safe access to healthcare facilities. And then the next one, and my numbers are going to be off, but this is, I'm calling it 7.1, is LD 1310, the criminal records sealing. The next one, which I'm numbering 7.2, is the ERA LD 344. The next one would be LD 54, post-conviction review.
And does that get a number 8? I'm just confused with the numbers. I'm sorry.
Yeah, it's because I originally numbered them and then I had to change my numbering system, but it was too confusing to change them all.
So 54 becomes what?
I believe
Was
that-
8, it's now number 10. I mean, either way.
Thank
do
you,
it.
Chris.
Got it.
Yeah.
So 54 would be number 10, post-conviction review. And then number 11 would be 1904, which is the juvenile code. And then 12 would be 1626, the bill that changes the main implementing act. Uh, 13 would be 1856, judicial branch paying bail commissioners. 14 would be 1950, the probate commission recommendations.
What happened to 1856?
Yeah.
I had that right after the criminal records.
I'm sorry, I'm getting really confused.
I think you
You
said
moved the criminal
1854.
records up. So 1856 comes right after 1626, the implementing act.
You just got the number wrong.
Okay, thank you.
So I
Was
think
there
it's
one
number
criminal
13.
records?
Okay,
You do want criminal records. Criminal records is 7.1, also known as 8.
Okay, that's the same thing then. Oh, that's what got moved up. That's what you're saying.
Yes.
Peggy, can you read me, please, the last two?
What I have is 1856, then 1950, and then 1326.
Thank you.
Is that what you have?
That is. And then the last one would be 1273.
Okay, and I have that as number 16 then.
Okay.
But
how are-
I
how are-
could have missed something.
Peggy, maybe I can just read down it one more time or actually, can you read your list and then I'll see if I can follow my notes.
So number 1 is the MCILS package of unanimous recommendations. 2 is the MCILS Kennebec Somerset Public Defender. 3 is a civil legal services baseline of $4 million. 4 is LD 906. 5 is 585. 6 is LD 844. 7 is LD 1899. 8 is LD 1310. 9 is LD 344. 10 is LD 54. 11 is LD 1904. 12 is LD 1626. 13 is LD 1856. 14 is LD 1950. 15 is LD 1326. 16 is LD 1273. Does that match what people thought?
Yes.
Very good.
Perfect. How's that feeling to people? Do we feel comfortable with that?
Yeah.
Probably would have number 7, safe access, even higher, but I think it's a pretty good list.
And I think those costs are because of the Class E crimes.
Okay.
Because Representative McCray and I have decided that the clinic can paint the damn sidewalk with our help. The city's sidewalk.
All right. Thank you, everyone. Peggy, what else do you need from us on this prioritization?
I'm not going to put a whole lot of pros together. I'll just list the bills in this order, if that's okay.
Okay, thank you.
Okay, great. And I know you still have the public records exception review for LD 1727. Have you postponed the amendment review for LD 2008, Representative Madigan's bill, for another day?
We should do that first.
Yeah, let's do that one first, please.
Is that what you want to do right now?
Yes.
We don't have a form.
We don't have to.
Okay, I don't want to stop you from finishing your prioritization if you have more to do.
I think we're good. I think we're ready to change gears to 2008.
Okay, for those of you in the room, there is a green copy of the draft of the final version of the amendment. And for those of you on Zoom, I will share. This is the majority amendment. It ought to pass as amended report on LD 2008, an act to establish a court process for involuntary substance use disorder. The amendment actually strikes the bill and creates a committee to study court-ordered treatment for substance use disorder. It does include an emergency. It is right now is made up of 14 members. There are 6 legislators, 3 from the House, 3 from the Senate. A member appointed by the governor, whoever the governor wants to appoint. There's somebody representing hospitals, somebody representing substance use disorder treatment providers, families affected by substance use disorder, 1 member with lived experience with substance use disorder, a member representing primary health care providers, a member representing hospital emergency department providers, and a member representing an organization whose primary mission is the protection of civil liberties. The duties are to review the services and processes currently available for persons with substance use disorder. I think you actually saw all these duties before. Finally, develop recommendations for treatment options, including implementation plans, and the report of November 2nd, which is the standard reporting date for reports in even years. So, and I think the only question I had heard was whether you wanted to change who was on it, whether you wanted to expand it or change the wording about hospital emergency department providers.
So Peggy, that was something that I had raised, wishing to include a one member from a statewide organization representing physicians. And I don't know whether, I know that if we added it as an 11th paragraph in section 2, we would have to reconsider. I don't know if it would be appropriate to if it's within the scope of language review, to make that change, for example, to either paragraph 8 or 9. What are your thoughts on that, if you wouldn't mind sharing?
You mean changing the language instead of primary healthcare providers representing a statewide organization of physicians?
Yeah.
I guess, you know, the wording of it, when you're just talking about the wording as opposed to kind of substantive pieces, I know, I'm sure primary healthcare providers might see that they're different than a statewide organization representing physicians. But I can see that would, however you want to handle that language is fine. I think if you're going to add another member, then I think you probably would need to reconsider and revote, making it 15 members from 14.
Yeah, and I guess personally, I would be more comfortable reconsidering and revoting. Can you, I know that this was a divided report.
Yep. Let's see if I can scroll to the voting sheet. Supi is great at getting me the voting sheet. So here's.
Oh, it's silly me. It's on the handout. Thank you all.
That's okay. So the minority report was ought not to pass. And there were 3 on that. So if you do reconsider, we can ask Supi to once again talk to members of the committee with a new voting sheet tomorrow. I'm going to stop sharing for now.
Okay, yeah.
You can see each other and decide how you want to go forward.
Committee members, is there anybody who feels uncomfortable with revoting and adding another line with that organization?
I'm not uncomfortable. I'm very comfortable with it. I mean, we heard, I thought pretty clearly from MMA that they wanted a physician by name. I think the bill sponsor was comfortable with that.
Okay. Is somebody willing to make a motion to reconsider? Representative Arnett is there a second? Seconded by Representative Evangelos. And so, so Supi is here and she'll call the roll on the motion to reconsider.
Point of order, Madam Chair. It's actually a question that I asked.
Yes.
This is merely procedural. So even though we're taking a roll, this is not something people weigh in on after the fact, whether or not we can reconsider. Correct. Thank you.
Unless it doesn't pass. Even then it's probably too late.
Okay, and so on the motion to reconsider, Supi's calling the roll, and it was Representative Arnett and Evangelos seconding.
Did you want me to call them? Okay.
Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Newell. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier. Senator Kime. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne. Representative Sheehan. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby. I'll recall the absentees. Representative Newell. Representative Newell is absent. Representative Poirier. Representative Poirier is absent. Senator Kime. Senator Kime is absent. Senator Sanborn. Senator Sanborn is absent. Representative Thorne. Representative Thorne is absent. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent.
We have
Representative
six.
Libby. Representative Libby is absent. 6, 7, 8, absent. Madam Chair, I have 6 members voting in the affirmative, 0 in the negative, and 8 members are absent. That is the vote of the committee.
Madam Chair, I
Yes.
don't think you have a quorum.
We do not. Okay, so we are, Peggy, when are we next meeting as a committee? Wednesday, are we doing, we're doing? a committee
Wednesday is
Wednesday?
Errors Bill work session, and then Friday, we're expecting the whole committee to meet.
So Wednesday is the Errors Bill Subcommittee.
Yes.
So I think we're just gonna have to take this up on Friday.
Okay.
Yeah.
Peggy, are you giving us the rest of the Errors Bill stuff tomorrow while we're up there?
I am really hoping so.
Okay.
Yes. Are you planning to be here, Representative Rector?
Tomorrow, yes.
Yes,
But
okay.
Wednesday not. No.
Right. I'm expecting the work session on Wednesday to be remote. So we're doing our darndest to get you copies of absolutely everything. So you can take it with you when you leave tomorrow. Are you going to have
Okay.
a long session tomorrow? Are you giving me lots of time to copy?
I haven't seen the calendars yet, so, because I haven't been able to get off of the Zoom to look.
Okay.
Hopefully not, but I don't know.
Okay, so we'll continue our work on LD 2008 on Friday morning. Are we able to do the public records exception without a quorum? Or should we take that up on Friday? Okay, so we'll have to take that up on Friday as well. And I can see that both in numbers and in energy, we are flagging a little bit. It's been a very long and busy day, so perhaps it's best for us to adjourn at this point. Okay.
Okay. Thank you.
All right, everyone. Thank you very much. See you all tomorrow.
Good night, everybody.
Thanks for all your wonderful work
Thank you.
today.
Good night, all.
Good night. Thank you,
Good night.
Peggy. Thanks, Sue.